Please, your lordship. Lordship, I beg to mention a motion matter for listing today, lordship. They are unlisted. Much obliged, lordship.
Please, your lordship. Your lordship, I beg to mention one pending writ petition for listing, your lordship. Urgency is there, your lordship. The eviction order has already been issued against the petitioner, your lordship. We challenge that order.
Eviction?
Yes, your lordship.
Okay, Monday.
I do it.
Prayer for requisition of additional affidavit in item 34. Highly obliged.
May I please, your lordship, I beg to mention the matter for listing. The writ petition. Your Honor, we have filed an, your lordship, we have filed an IA for eviction of vacation of ex parte interim order. Therefore, may be listed on 2nd of September.
No. Not on second. Fixed.
Must I?
May it please your lordship. Your lordship, with the concern of the other side, I beg to mention item number 23, your lordship. In this matter, I am praying for an adjournment, your lordship.
Why?
Conducting counsel, Mr. P. Deca is having some medical emergency. I have
At the request of the learned counsel for the petitioner, matters can be adjourned to be listed after 4 weeks.
highly obliged.
May please, your lordship, I beg to mention item number 18, your lordship. But can it be adjourned for today because Mr. K. Chaudhary is not available in town today, lordship?
Not on that.
Lordship, not on that.
Not on that.
And moreover, lordship, actually.
I don't believe adjournment on senior counsel.
Yes, lordship, I understand that. Lordship, but the issue is here, lordship, but if I may be permitted to say.
You may rephrase your request for argument, adjournment was on some other grounds.
Lordship, actually, the thing, the forest department, there is a PIL, which is pending before the honorable division bench, where the forest department has to place a map, survey map. And because of that, this petition also cannot be decided without that survey, your lordship, without that report. That is also a.
We'll see when the PhD comes then.
How much of this?
Map is lordship.
Yes, why such a old matter?
Lordship, in this case, the original petition had expired.
What are you asking for? Does anything survive?
Yes, lordship.
Nothing
I have
has happened
already
for the
filed
last
3
2
IAs.
years. What are you asking? Order passed by the Board of Revenue
Yes, sir.
in view of the pendency of title suit.
Lordship, yes.
Why?
That, I have filed 3 IAs, lordship, in respect of substitution of the legal heirs of the petitioner as well as for conversion and second settlement. Those that mean not been tagged.
So what is your ground?
My ground, lordship, is that in respect of lordship, for substitution or this matter, because I have already filed 3 IAs, your lordship. This has not been tagged, lordship, because in respect of substitution, I have filed 1 condemnation application as well as for setting aside the eviction. Because the lordship, what had happened in this case, after filing of this case, your lordship has well known that COVID has appeared, and thereafter, in the meantime, the original petition had expired. And
When?
original petition had expired, your lordship, on 8/5/2022.
8/5?
2022.
Then?
And the knowledge of the death was not aware to me also, as well as lordship, the legal heir, who is the wife, aged about 66 years, she is also not aware of the pendency of this case. So we could not even contact, as this matter could be known that this matter has been listed, lordship, today. We have tried to contact him, but as known, your lordship, that he has expired, and accordingly we have contacted the legal heir, and accordingly we have filed the instant IAs, your lordship, yesterday itself. because the petitioner, the applicant was also not aware.
Learned counsel for the petitioner submits that certain applications have been filed for substitution of the legal representative of the petitioner who expired in the year 2021-22. This list the instant matter on 29/2024, along with the said interlocutory application.
Right.
Yeah, please, Your Lordship. This letter ought to have been come to the admission list, but it has come in the motion list. So here, Your Lordship, what has happened? Here, I was in the catering service. For,
What are you challenging?
yes, Your Lordship, may kindly see. We are challenging. Actually, item number 3 ought to have been taken first, Lordship, because
Okay.
item number 3 is the one which was first filed by us.
What is that?
Kindly see, we are challenging the speaking order.
What speaking order?
Page number 86, debarring us, blacklisting us on the ground that our food is substandard. Actually, what has happened, Lordship? We have filed this writ petition for our bills, clearance of our bill. And we have shown concern to the,
Where is that order?
it is page 18, page 86, Lordship, annexure 18. Last page.
Where it has been observed that so-and-so, contractor so-and-so was engaged as a contractor for providing food of so-and-so. In the utility day by day. Okay,
Then, Lordship, we were blacklisted. So we filed the one, another writ petition, 2651, that is in the item number 2. In item number 3, they have filed affidavit, Lordship.
what is for two for what?
2 is for blacklisting us, for removing us from the blacklisting, and for paying our outstanding dues. What has happened, Lordship? We have been blacklisted. Then the DC Kashar has passed an order debarring us to participate in all tenders throughout Assam. We say that that is beyond his jurisdiction. He cannot do this. That is the moot concern of this writ petition, Lordship. Both the writ petitions
That
are.
is number one. Now, what is about number two? The second writ petition.
Yes, Lordship.
What are you challenging?
It is challenging the order till 13/4/2023.
Page? Huh? You are not aware.
Lordship,
The
annexure number,
counsel appearing on behalf of the petitioner has not read
Lordship,
his
see
brief
annexure number 10,
and
Lordship.
as such.
Annexure number 10,
Yes, sir. That is
Page
take such a long
44.
time.
page 44, Lordship.
Page
44,
40?
44. Double four, Lordship.
Yes, what is this?
View of the above activities as well as the violation of so-and-so, contractor, catering and supplier of regular is hereby blacklisted. And as such, so-and-so, catering, supplier Assam is debarred from taking participate in the official work tender of government of Assam. The same thing, Lordship.
Then why you are challenging two?
No, earlier, Lordship, we filed the writ petition for clearance of our bill. When we filed the writ petition for clearance of our bill, they issued this annexure for annexure 10, page 44. That no, you are debarred.
The first writ petition is for your bill. No. First writ petition is challenging 13/4. And second writ petition is for what?
Second writ petition. Yes,
Huh?
because there was.
Why you are
speaking of-
challenging both together? Two writ petitions, why you are filing?
In the first institution, deputy governor is not a party law. In the first institution.
In the first writ petition, Assam University, who has debarred me from participating in the tender due to the order passed by the DC. So,
Mr. Counsel, first writ petition is for challenging 13/4. That is 2282 of 2023.
no,
Why the second writ petition is for what?
what has happened after the DC has passed the order, NIT and Assam University also debarred me. In the second writ petition, their DC is not a party, Lordship. But on the order of the DC, they also debarred me. That is why the second writ petition has been filed, Lordship.
Second is challenging 26-4.
Lordship,
No,
actually,
no.
item number 3 ought to have been the first one.
Mr. Counsel, don't confuse this court. You
Sure.
don't know. The first writ petition which you have filed is challenging 13-4-2023. And the second writ petition is challenging two orders. One is 24-2023 and the other is 26-4-2023. Then
That is based on the order
maybe
Passed
on the
by the
basis
DC.
of 13-4.
13-4.
Then
Then I have been blacklisted, Lordship. I am not being allowed to continue with my work, Lordship.
then
That is.
we gotta
that is-
stay.
No, no.
Interesting.
It is mine.
Issue notice.
Item number,
Return.
Lordship will kindly see.
No, Mr. Counsel, we'll issue notice. I would not have otherwise issued notice. Only ground you have is you cannot blacklist somebody for any without specifying a period. It is after all a civil death.
Lordship, I kindly have a look.
Otherwise, it's okay. But the question is, can you blacklist somebody for all times to come? No. That's it.
If I can take your Lordship to order date 31/5/2023, Lordship.
Of
Of this honorable court, Lordship.
yes.
Here, Lordship, accordingly, it is provided that in event the respondent do not file their affidavit in opposition, therefore the interim relief shall be considered on the next day.
Absolutely. First of all, when the
And-
court does not issue notice, why will they file affidavit? Why will they file affidavit? We issue notice, দুইটাতে issue notice, এনেকে লিখো, both the, এনেকে লিখো, দুইটা লিখো, issue notice returnable on 25/9/2024. Who appears for whom?
Item number 3, affidavit has been filed by respondent number 3.
It be filed.
We may
Without
be kindly
issuing
allowed to
notice,
give
how can it be done?
So, আপনাদের
You can't keep these matters like this. Miss A item number ekonot kumkhon asil 2282. Mr. N. Goswami appears for respond number 1, 2,
3, 4.
3, 4, 5, 4. And he appears for, who appears for the health? Okay, none appears for the health department on 4. Accordingly, extra copies of the writ petitions be served upon them, upon Mr. N. Goswami, who appears for the respond number 1 to 4 during the course of the day. As regards the respondent number 5, the petitioner is directed to serve extra copy to Mr. B. Gogoi, the learned standing counsel of the health department. Who's to list this matter,
Lordship, respondent number 3 has already filed their affidavit, Lordship.
maybe. So list accordingly. And to declare issue notice, yeah. Issue notice, Mr. Kyle, you are appearing for Assam University. SC Kyle appears for Assam, who appears for the NIT?
My lord.
And what is this? The Dean, Students Welfare, what type of this thing is this? Number 2, who is number 2?
What?
Wait,
He has issued the notice to us, Lordship.
so? How can you make a Dean a party? Whom should you make a party? The NIT?
Yes, yes.
Then
Yes, correct.
why NIT is not there?
Some university also not part. Some university also.
Register Assam.
Assam University is not a party. How are you challenging this
Let
type
me
of?
make corrections, Lordship. You kindly allow to-
Withdraw, file a fresh one.
I will amend it if your Lordship.
You can't amend this. How can you amend this? File a fresh one, this one.
Lordship. The liberty I may be. allowed to-
I'll give you a liberty. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits that there is certain formal defects in arraying the parties in the instant writ petition. Which he therefore submits that he may be permitted to withdraw the instant writ petition with a liberty to refile. First, taking into account the said submission and also upon perusal of the materials on record, this court closes the instant petition on withdrawal, which, however, liberty is given to the petitioner to assail the impugned orders by making the by rectifying the formal defects.
If you oblige.
Our economic notice issued so and so on 23/9. In the meantime, the respondents shall bring on record their stand by filing the affidavits. 2 AR হয়েছে দে 2 withdraw, no 2 withdraw হয়েছে 3 Mr. B. Gogoi, in item number 3, item number 3, I have issued notice. I put your name. Mr. B. Gogoi represents the respondent number 6. Huh? Okay, what is this?
My lord, operative portion of the impugned order is at page 13, my lord. There was a specific direction to clear the dues of the contractual amount of the petitioner within a period of, maximum period of 1 year.
Direction to whom?
Direction to the respondents, not particular any respondent.
Who?
But here in this respondent, acting respondent is the respondent number 2.
Direction is to whom? Is duty bound to release. So Mongoldoy Municipal Board.
Yes, executive officer is the main function.
Okay, you have issued, you have given it 27/2/2023.
Yes, madam. Then, my lord, we have approached by virtue of.
When would the period complete?
Period will complete from the date of 27 to February 23 to 27 to 2024. 24.
But they have not paid
They have not paid,
a single penny.
not pending.
Issue notice, this is an application filed under section 12 of the Contempt of Court Act 1971 for initiation of contempt proceedings against the executive officer Mongoldoy Municipal Board on account of the alleged and deliberate violation to the order passed by this order dated 10/2/2023, passed by this court in WPC number 411/2020. Issue notice making it returnable on 30/9/2024. Steps be taken by way of registered as well as usual. You want the money early? Will you take dusty service? If you take dusty service, the money will come because they will fear more.
As
What
your
do you
lord-
say?
As your lordship,
No, it is for you.
I can. Also, my lord, stays by registered post.
That I have given.
Yes,
But you want to take dusty.
yes.
The petitioner is further directed to take dusty service upon the respondent by way routed to the registry of court and file an affidavit of service on or before the custom. On or before the returnable day, the respondent is directed to apprise this court by way of an affidavit as to whether the directions passed by this court dated 10/2/2023 in WPC number 411/2020 have been complied with.
May it please your lordship. Lordship, I may be allowed to withdraw this petition, my lord, with a liberty to file afresh.
Why?
There were some formal defects. my
What?
lord, the addition of
Afresh?
parties.
Why afresh?
My lord, some
There's
petition.
no afresh business out here. Directing the respondents to act on the representation dated so and so and refer the title dispute of the acquisition to a competent civil court for adjudication and further suspend the disbursement of it. Now, why do you want to withdraw?
Lordship, some formal defects were there in the petition, Lordship. We want to.
What are the formal defects?
Lordship, the addition of parties was required to be made.
Whom you want to make parties?
Lordship, I don't have instruction.
Whom you want to make party?
Lordship. The
The learned counsel appearing on behalf of the petitioner seeks for an accommodation, list the matter of 2 weeks. Find out whom you want to make a
Lordship.
party.
deeply obliged.
In the meantime, why don't you file an IA then?
Lordship,
I'm fixing it after 2 weeks. Why don't you file an IA including? If that is the defect,
deeply obliged.
yes, what is this?
Lordship, here willful and deliberate violation of order dated
Huh?
502/2024.
Ex-gratia.
Yes, Lordship, operative part at page 13, your Lordship, paragraph number 10.
Ex-gratia 15 to 2024. When the money was to be paid? Within 3 months?
Yes, Lordship.
The instant application is filed under Section 11 and 12 by invoking Section 11 and 12 of the Contempt of Court Act 1971, alleging willful and deliberate violation to the order dated 5/2/2024, passed in WPC number 7027/2022. First, this court issue notice making it returnable on 4th of October 2024. First, the petitioner is directed to take steps by way of registered as well as usual.
Deeply obliged.
Item 7.
May I please, your Lordship.
Hmm.
Lordship, petitioners are the legal heirs, Lordship, of one government employee, deceased employee, Lordship, Concerning Gogoi, Lordship. Lordship, who died in COVID-19, Lordship, while performing his official duty, Lordship. Lordship, the government of Assam, Revenue and Disaster Management Department, Lordship, had issued a office memorandum, Lordship, dated 8/10/2020, Lordship, to pay 50 lakhs rupees, Lordship, as ex-gratia,
You are a COVID
Lordship,
the warrior
Lordship,
who died. And you want that 50 lakhs,
ex-gratia amount, Lordship.
ex-gratia amount. Issue notice making it returnable on 23rd of October 2024. Mr. Who appears for revenue 1? Mr. Arbopati appears for respond number 1
Also, my lord.
and 2.
Yes, my lord.
And why the Director General of Police? What business he has?
Lordship, he was a policeman, Lordship.
Okay.
That is the administrative authority, my lord.
Mr. N. Goswami appears for the respond number 3, 4, and 5. First, as the respondents are duly represented, extra copies of the petition be served upon them during the course of the day. First, the case of the petitioners herein are that they are who died?
Lordship, Concerning Gogoi, Lordship.
My lord,
Yeah.
the husband of petitioner 1 and fathers of petitioner 2 and 3.
That the case of the petitioners herein is that the case of the petitioner herein that the husband of the petitioner number 1 and the father of the petitioner number 2 and 3, who was a police personnel,
Lordship,
expired during the COVID period while performing duties. Gusto. In terms with the office memorandum dated 8/10/2020, the government of Assam had issued a office, yeah, and had initiated a policy that the persons, the professionals, that the next of the kin of the legal heir of the persons whose name, who were employed in the respective professions stated in clauses Roman 1 to Roman, subclauses Roman 1 to Roman 7 of clause 1 of the office memorandum dated 8/10/2020 and died due to COVID-19 while performing official duties in combating the COVID-19 pandemic would be entitled to an amount of rupees 50 lakhs in one installment. It is the case of the petitioner that the husband of the petitioner number 1 and the father of the petitioner number 2 and 3, while working as while discharging functions as the assistant sub-inspector in Jorad DEF, expired on 2/10/2020 due to COVID virus, bracket COVID-19, while performing his official duty. Thereupon, various requests were made for release of the said ex-gratia payment. However, the same have not been released, and it is under such circumstances the petitioner has approached this court by filing the instant petition. The respondents are directed to bring on record their stand by filing their affidavit on or before the next. New type of ex-gratia we are getting now.
I would like to.
Yes, Mr. Mandal.
May I please? My lord, the petitioner limited prayer, my lord, before this noble court, lordship will find at page 32. Now, since it is a notified service, page 32, madam.
Why you are filing it in this manner? There is a particular form in which you have to file, isn't it? As per the office memorandum dated 25.
My lord, we will file in the my
I
lord,
have
prescribed
already
form.
mailed I have already mailed the notification, Lordship.
There is a particular manner in which you have to file. Office memorandum.
Embarkation, Lordship, 21 December 2020, Lordship.
There is a, kindly read the clause number 2, if you have, the manner in which it is to be filed. I think clause number 3 or 4. It is given there.
Sir?
How? There is a particular manner.
Lordship. Standard format. Application must be submit duly signed application form mentioning details of the schedule DAG number, up to date of the revenue receipt, user charges ₹30, citizen certain annex 1, and 30 days working time, Lordship.
I'll file.
Mr. M.U. Mondal, the learned counsel appearing on behalf of the petitioner submits that in view of the office memorandum dated
21 December 2020.
20, the petitioner would, instead of pressing the instant petition, file the application as mandate in the procedure mandated in the said office memorandum. He therefore submits that he may be permitted to withdraw the instant petition, and if so agreed at a later stage, he may be permitted to approach. Taking into account the above, the instant petition stands closed on withdrawal. The petitioner, it is further observed and directed that if the petitioner files such application in the manner provided in the office memorandum dated so and so, the concerned respondent authorities shall duly take note of the same and process the same in accordance with the said office memorandum.
Yes, doctor.
Item 9.
Yes, what is
Again, the
this?
eviction order
Where?
in really. Actually, not that all area is a huge area. There are more or less 500 families, my lord. But only me, they have passed the eviction order.
Where?
On
Page,
16 to 2016,
page.
page number 33 to 34.
Appeal dismissed.
I will dismiss, my lord.
So what is your ground?
I'm not against them, but there is a huge, large area.
Hmm.
There are more or less 500 families there. Only me is order for eviction only in 1/10 letter for the purpose of railway purpose.
Where is railway? Yesterday, this type of matters were before me. I said that 3 months. Vacate. Nothing doing. Here the land is the railway land as per the, this is the same type of orders. Where the circle officer was brought in, he gave the evidence as a court witness. This also must have been the same thing. Your only case is that no, it is not a railway land, it is a government land.
Government land.
Okay? Nothing. Yes, same judge. How many? How many? 3 months.
6 months. 6 months.
3 months. And file an undertaking by tomorrow. We'll have it tomorrow, file an undertaking. Or you want it by tomorrow, I can issue notice tomorrow. Yes, where is the railway? You are there?
I can appear.
Yes. You inform Mr. K. Gogoi is also there in
Yes,
that
sir.
batch. Yesterday it was there, moved by Mr. T. H. Hazurika. কালি এটা যে order দিছিল এইটো unlisted এইটো যোনটো order হ'ব make it returnable by tomorrow. In the meantime, file your affidavit giving an undertaking that you are vacating within 3 months. Else I'm dismissing it. Once I dismiss, immediately you will be thrown out. I'm saying it from today till tomorrow. One day you are getting.
6 months.
No, I've already passed an order. 6 months, not possible. 3 months, because there is an infrastructure project which is coming up. And that is the reason why. And all, not your case.
In not that area, actually. Their project is not in that area. There's no general notice, my lord, for that area. There's no general notice.
No, this is the Pandu
Only
area.
for person.
No, nothing. No case. I call Mr. K. Gogoi. I'll take your matter after some time. Ask Mr. K. Gogoi to look at them because he is the person.
Yeah, please, Your Lordship.
Yes, what is this?
Petition is a software engineer,
Huh?
working in a multinational company.
What do you want?
My lord, I have my.
Directing
passport
the
was
response pursuant 3 and 4 to renew the passport of the petitioner who had applied by an. Why?
Well,
Your
it was
passport have not been renewed?
renewed because of the pendency of a criminal case, my lord. My lord, as per Passport Act, there is there, but subsequently, GSR, my lord, General Statutory Rules, my lord, I take a lordship page 32, before that page 31, Annex 10, my lord. This is the letter issued by authority respondent number 4, my lord, in pursuant
You
to the
are-
my application.
As per the request of the hearing, you are required to fulfill the requirement prescribed in the Gazette. Notification available in here and no objections to a court order permitting for travel abroad along with the prescribed notification. If cases are arrayed against you before several courts, then you are required to get the NOC from all courts. Then,
Now, I take your lordship page 32, Annex 1.
Ah.
This is the OM, my lord, GSR, my lord.
Here, it was exempted, provided, honorable court's order is required. I am reading,
Provided,
provide from the court concerned, no objection for the time being 1 year, 2 years, as this honorable court may satisfy, It can be exempted, I am reading, in exercise of power conferred upon clause A of section 22 of the Passport Act 1967 and in suppression of the notification of the Government of India in the Ministry of External Affairs, DSR number such and such, the central government being of the opinion that it is necessary in public interest to do so, hereby exempt citizen of India against whom proceeding in respect of an offence alleged to have been committed by them are pending before a criminal court in India, who produce orders from the court concerned permitting them to depart from India for the operation of the provision such and such.
then did you apply?
Yeah, I have applied the 498A, it is pending almost at the final stage. I
Where?
applied before the.
Where is your
court,
application?
My-
Where is the order?
My lord, I take ownership order at page 19, my lord,
Page?
19. Case pending before the CJM. Paragraph 3. Having gone through the contents of the petition, this court of the opinion that the only passport authority has the power to renew the passport issue against the petitioner. It is the absolute discretionary power of the passport authority to renew or not to renew the passport against the petitioner.
Then what? Where did you take the no objection?
My lord,
That they have no objection.
the court where the cause is pending, my lord, it is a CGM, my lord. The CGM has no power in the order.
You are only to ask from the CJM, that look here,
Right.
I want to renew my passport, I have to go somewhere for some purpose. Kindly give me a short time that yeah, subject to whatever conditions you know. You don't ask the court to renew. They are not going to renew.
My lord, that is-
But you want the no objection.
Right.
But what you ask is for seeking renewal.
my lord,
Then
my
fill
lord,
your application
Oh.
properly.
my lord, my lord,
You apply for the application properly.
my lord, the court below maybe give a direction. Well, I have the judgment of the appeals court, my lord, on which I have,
For what?
my lord, this of appeals court only done.
No, you are not filing, you are not fulfilling the criteria, your petition was rejected. And if it was rejected, you should have gone under 482.
No, my lord, I cannot go for it. There is incorrect, my lord, that was in the court below.
What is this?
My lord, I am reading some of the High Court judgment, apex court, my lord, para 5, my lord.
Error 5.
Bangala Kasturi, my lord. The refusal of a passport can only be in case where an applicant is convicted during the period of 5 years immediately preceding the date of the application.
No, Mr. Counsel, whatever may be here,
Well,
the Supreme Court may have stated out
Passport
there
authority is
regarding the
directed-
passport. But here is the question that you are to apply the passport in a particular manner. Can be made only in a case where an applicant is convicted during the 5 years.
Well.
As per this.
Well.
But what do you say about F?
The passport authority is
The
directed.
the
to
proceeding
give
in
the
respect of an offence alleged to have been committed are pending before the criminal courts in India. 6-2F,
My lord, 6.
immediately preceding the date of the for an offence of moral turpitude and so and so.
Well,
Admittedly, relates to a situation where the applicant is facing. Admittedly, at present, the conviction stands till the disposal of the Iman, the sentence which have been has no to undergo for a period. The passport cannot refuse the renewal on the ground of pendency of a criminal appeal. The passport authority is directed to renew the passport of the applicant without raising the objection relating to the pendency of the criminal appeal in the court subject to other conditions being filed.
period, even GSR provided, my lord, it can be issued only for 1 year also, my lord. 9 months also. My lord, I take ownership the GSR, statutory rules, my lord.
Anyway, we should short notice. Where do you want to go?
My lord, France.
Huh?
France. France.
Why? Olympic is over.
That is for,
No.
that invitation was for 18/6/23. So more than 1 year gone, for which he was asked to attend. Now he wants a
My lord, even 16 August, I appear before the trial court, medical officer.
What you asked out there is the wrong thing. That you made a wrong application. You
My-
should have got in that look here, in view of this judgment. Why are you going into this? In view of this judgment, nothing is there, but then also kindly give me so that I can comply. The trial court will give that no objection and get the support from here and pass the order, matter over. So you are filing a writ, or you don't want to go to the trial courts. Those courts are also air conditioned nowadays. Then
Your lordship can give a direction also.
why should I give a direction?
Approach the.
I can only say that you can very well approach. You want to withdraw the petition and approach, and I think this can be very well done before the trial.
That observation with the appropriate application, because to be fair enough, the application is to some extent prayer is some extent not correct.
No.
That observation may.
Heard Mr. A.K. Hussain, the learned counsel appearing on behalf of the petitioner, and Ms. B. Sharma, the learned counsel appearing on behalf of the respondents. The petitioner hearing is aggrieved by the non-renewal of the passport of the petitioner by the respondent number 3 and 4. In that regard, the learned counsel, before appearing on behalf of the petitioner, has drawn the attention of this court to the letter issued by the to the office memorandum dated 10th of October 2019, wherein at serial number 3, wherein at paragraph number 3, it has been mentioned that with the due approval of the court before which the proceedings are pending, an application can be very well filed taking permission from the court that there is a need to travel abroad for some urgent business. And the trial court shall, on the basis of such application, pass appropriate orders for granting the applicant appropriate orders, thereby stating its no objection for issuance of a passport with short validity of 1 year or for the period specified by the court. So this court had also duly taken note of the application which was filed before the court of the Chief Judicial Magistrate Bongaigaon by the petitioner, and the order so passed on 17/3/2023.
Another one. Next, another one was there. That is 6/9/6/2024, page 23.
As well as the order dated 9/6/2024. In both the applications, it seems that the prayer so made is for appropriate directions for renewal of the passport, which obviously the said court would not have the jurisdiction to do so. But as per the mandate, be that as it may, as per the mandate of the office memorandum dated 10/10/2019, the court before whom a criminal proceedings are pending, before which a criminal proceedings is pending, can very well allow grant a no objection for issuance of a short validity passport of 1 year validity or for the period specified by the court. The learned counsel for the petitioner, in view of the above observation, submits that he may be permitted to move the court before whom the criminal proceedings are pending in the light of the above observations and obtain and get the no objection so that the passport authority can renew the passport in terms with the office memorandum dated 10/10/2019. Ms. B. Sharma, the learned counsel appearing on behalf of the respondent numbers 1 to 4 submits that the passport authority would have no objection if the office memorandum dated 10/10/2019 is duly complied with. Taking into account the above, this court disposes of the instant writ petition, thereby granting the liberty to the petitioner to approach the court of the where judicial magistrate.
Bangaigaon.
Yeah, before the chief judicial magistrate, Bongaigaon, in PRC case number 268/2019. Before whom PRC case number 268/2019 is pending, to apply for the no objection in terms with paragraph number 3 of the office memorandum dated 10/10/2019. Upon such application being filed, the learned chief judicial magistrate shall duly apply its mind on the basis of the said office memorandum as well as the observations made herein above. In addition to that, the court shall also take due note of the judgment of the Supreme Court in the case of Vagala Kasturi Rangcharyalu versus Central Bureau of Investigation, reported in what?
Well, it's a 2021 SC 99.
Judgment of the Supreme Court dated 27/9/2021, passed in Bangala Kasturi Radiusu versus Central Bureau of Investigation. Hey, come to Salivudi.
Hello. Yes.
Standing matter, I don't like.
Oh, yes. Same na?
Same.
We'll have it tomorrow.
Tomorrow, Roshi, they have to be undertaken.
Kali he order to into this not to evict till tomorrow, subject to you filing an undertaking that you are going to vacate within 3 months. Same on.
They, our persons are ready. That's because Roshi,
Don't allow
that's
them.
why we have Roshi.
Because tomorrow, because what happens, once that undertaking is given, then we pick up. Then what happens, you see, the matter comes to a closure. Otherwise, this will again, if I pass a order, stay or something, or don't do it, again, another round of litigation.
When after I received the message from Roship's court, Roship, just I have intimated them not to evict them. That's because there are 8 persons there. Yesterday, 5 matters were listed, we abandoned 5 Roship. Another 2 is Roship going on. Now this one, we stop Roship.
Stop.
Roship.
We'll have it tomorrow.
Roship.
And you undertaking today, so that it comes tomorrow.
Roship.
Kali matter hai. Because
Roship.
at the top of the list. Hey, Kali, itu amar Pradipor order to us.
Roship.
Hey, Gogoi.
I don't remember.
Mr. Gogoi, tomorrow, when the matter is taken up, na,
Roship.
just find out what is the infrastructure project.
Roship.
But that would be required because if in any case, some petitioner do not file, I have to say that.
Roship. I'll
Yes, Mr. Chauhan.
My lord, the case, my lord, for withdrawal, my lord, is covered by the cabinet decision and SOP, my lord.
As to why the
Correct,
cabinet
yes,
decision
yes,
dated
yes,
so and so as standard
Based on
issued
my
thereunder shall
seven-
not be followed in letter and spirit by the respondent. And to show cause as to why the PRC case will not be withdrawn, which have been pending in the court of Hamren in the event of not following the cabinet decision as shown. How can I issue a writ?
Because my lord,
Cabinet decision is not enforceable.
my lord, cabinet disapproval, my lord, coupled with my lord, can you see my lord, page 17? My lord,
Eight,
the LR come, my lord, Commissioner and Secretary, Judicial Department.
no, this has gone for this thing, I think they are doing something. Anybody from the government?
Yes.
You are taking some review decision on this, no? Because there is some problem because of the power and jurisdiction to do so.
There is some class, definitely it is likely to be, obviously it is to be reviewed now. So
Because there
understand
is
the-
some, because there is a lot of problems in this regard.
Definitely,
I think this is not in accordance with the stipulated procedure.
yes.
And the cabinet decision, you can't do it. One fine day, the cabinet comes up, yes, very well, they were, for good reasons, they must have done that all 3 years we are. But what is going to happen to all the people who are affected?
Well, many cases already.
And
they have
everybody now, what has happened, have now, once, the problem which has arisen is like this. On one hand, the government is withdrawing, that is the state is withdrawing. Then the other person who is the sufferer, he is filing complaint.
SOP,
The reason why the government did it is for the purpose that we are going to show that the criminal cases have come down.
Down.
Now, what has happened? It has taken the other effect. These have now become complaint cases. And not only that, the second round of litigation is all before the courts, where 482 are filed that when the government has withdrawn, how can there be a complaint case?
Yes.
Then the question arose as to how the government can do so. Now the government is rethinking that they could not have done this.
Ultimately, the load of the judiciary remains the same.
It became more.
It may more.
Because not only there were matters before the courts, now all these matters have again come back by way of this complaint proceedings. And secondly, all these matters have 50% has come before the high courts.
Yes.
So the thing which was 100, now it has become 150 because of this issue. To reduce.
Many cases already withdrawn, my lord. Many cases already withdrawn.
So therefore, all complaints are being filed now. These people are filing complaint petitions. Then maximum of the matters are coming before the High Court. Then when the state have withdrawn, because there is one stay granted by one of the courts, matter now everybody is coming. Then when the state has withdrawn, because every offense is against the state has withdrawn, who are you? This is
If my lord they withdraw, may review my lord, that is different thing, my lord. Till today, my lord, it is not reviewed, my lord. As per SOP, my lord,
anyways.
is their
We
duty.
do one thing. We won't dismiss it on the right day today. We issue notice sometime in month of December.
Remember.
By then it will be done. Issue notice making it returnable on 6th of November 2024. Mr. Esbur appears for the response number 1, 2, and 3. The petition is herein. Yeah, I can make it go. Extra copies. The petitioners herein are aggrieved by the inaction on the part of the respondent authorities in not complying with the cabinet decision dated, where is it?
7/9/22.
11/9,
22 is reflected in order
11/9/2022 and the standard operating procedure
dated
issued therein under. Whereby? Whereby? Cases wherein the punishment is up to 3 years under the Indian Penal Code or any other special act of the regulation registered up to 14/8/2022 were to be withdrawn except certain categories of cases. The case of the petitioners herein is that the PRC case number
PSA 431 of 19. 431 of 19.
oblique 19 falls within the ambit of the said operating procedure, standard operating procedure. However, the respondents have not withdrawn. The respondents shall bring on record their stand by filing their affidavit on or before the next. Yes, Mr. Bhuya.
My lord, my lord. My lord, I am a victim of, my lord, this cyber crime, my lord. My lord, complaint had been lodged, but my lord, when the account has not yet been freezed, as well as, my lord, transactions are still going on through the hackers, my lord. The hackers is now in the full control of my, my lord, corporate bank account, and still the transactions are going on.
They have not closed it?
They have not freezed it, my lord. The bank official has not, my lord, freezed it yet, my lord. I have approached the bank manager, of the concerned bank also, my lord.
Then?
That's the reason, my lord, why I had to, and my lord, what has happened, several complaints had been lodged against my,
How are the amounts being debited? Let's see.
my lord, I have stated, my lord, in the,
Now kindly come to page 41.
yes, my lord, the page 41. My lord, the unauthorized transaction took place, my lord may be pleased to find, page 42, my lord. First two, my lord, maybe skip the third one, 11/1/24, transferred to so and so, 18,000 rupees. Then again on 11/1, my lord. Then again, my lord, skipping 1, 2, 3, 11/1/24, 15,000.
No, when you report, where's your representation?
My lord, my report is initial report, my lord.
Where's your representation?
Yes, my lord, my lord may be pleased to find is that this is the National Cybercrime Reporting Portal at page 37, my lord, annexure 6.
Huh?
Page 37, my lord, may kindly have a look. There is an online reporting system is there, my lord, if something happens. So by, my lord, invoking that online, I have reported this, my lord. This is my acknowledgement number of my report. And, my lord, responding to this, SMS has also been acknowledged at page
Has been
30.
put on hold, 17,100 has been.
My lord,
Then where's your thing that it is every day going on?
Hello?
Where is it that every day it is going on?
My lord, the evidence, yes, my lord, the evidence, the last statement which I have, my lord, collected from the, my lord, maybe please to find. Is
But
that
these happened in the month of January
January and
2024.
July
Now
also.
we are in the month of August. What are you doing?
July also, my lord, there are some transactions are there.
Where is it?
Yes, my lord, I am referring to that, my lord. My lord, at page 46. This is a, my lord,
Mr. Bhuya,
my lord.
you have a good case, but you have not made the case in a better manner.
My lord, actually, whole thing is, my lord, not in a very organized manner, my lord. The document which has.
No, not in an organized manner means, you see what you ought to have done, there is a circular of the RBI. The moment it is informed, you are to inform. The moment you are getting a transaction, you are to inform within 3 days.
My lord.
The moment you inform, they have to put it on hold. Then they would be liable to return you the money.
Exactly.
Where you have done anything to that effect, nothing you are doing.
My lord,
I can very well issue a notice, but at the end of the day, you see, this is a case of urgent nature.
Urgent
But
nature.
this is not going to help you. You have not approached it in the right manner.
That is
You
correct.
see, you are FIR is of 22 to 2024 and there is nothing more. Tell me, why you are not doing it?
Actually, my lord, he has approached late, my lord.
They have approached late, but you have suggestion is also very late.
Fine.
You should have suggested it properly. So your case, do you have that that circular of the Reserve Bank of India?
My lord.
Then why you are not asking him to do it in that manner? Then only he can get something. And if it is today also happening, you see, therefore, it's very difficult to understand when you have already informed that there is a case of fraud. Where you have approached?
Lord, the national.
That you have stated is only for 17,100. Thereafter, where did you approach? There's
That-
nothing, not a single document.
My lord, I have approached the
At the
concern.
end of the day, you may not have a single penny if this is going on. There's no representation, nothing. Forget about representation. Where is your complaint? They kindly stop my bank account.
Fine.
Nothing. You are only saying that one account is, one amount is taken and that is why that has been put on hold. They have done it. But where have you informed? You should have informed or asked him to kindly block my account. Or these transactions out there, all these transactions are fraudulent.
Yes.
And kindly ask the CBI, the police station to look into this.
My lord. That approach is lacking, my lord.
Not done.
My lord. The bank official can, my lord, can apprise my lordship, my lord, actually what.
And you are not making the State of Bank of India party. Who is this branch manager business?
My lord.
It may be represented by a branch manager, but you make the head office out here a party. Once you make the head office out here a party, then only things will move. By the time this will go and reach Dhing in Hoibergaon, all of your money will go. I can't do anything. I can't help you unless you come up properly. Have you seen that Reserve Bank circular?
No.
Then ask somebody.
Fine.
Ask these people. There are many lawyers who have done matters to that effect. And there is a standing counsel also of the State Bank. Give it a copy, then the only things will move. But this way your petition, at the end of the day, you may not be getting anything. You can issue a notice, but this is not going to help you. Okay, issue notice.
Alright.
Making it returnable on 23rd of September 2024. Ms. Esburu appears on behalf of the respondent number 1, 2, 3. As regards the respondent number 4 and 5, steps be taken by way of registered as well as usual. The case of the petitioner herein is that the petitioner has an account with the State Bank of India bearing current account,
My lord.
number 396-505-16301. It is the case of the petitioner that the said account has been, in the said account, various fraudulent, in the said account, there has been various fraudulent transactions being carried out by certain miscreants. And as such had requested the State Bank of India as well as the official respondents to take appropriate steps. As such, the petition has approached the State Bank and the branch manager of the respective branches of the State Bank of India as well as the official respondents. However, nothing has been done for which the instant with petition has been filed. The respondents shall bring on record their stand by filing an affidavit. It is not going to help you. Only satisfaction is that you are getting a notice. Should have made the case better. And there is a very good way to watch. There is another proceedings I am taking up. That is a matter pertaining to again the State Bank of India. It's a very important matter which I am having it. A pensioner's money has been taken away. I think it is on 6th or 7th or 4th of September. 6th of September. 5th of September. Yes, what is this?
This is for protection of the school land.
Huh?
School property, school land. This is meant particularly the school.
Hand over the land concerning government dark number relates to Iman without detecting the playground.
My lord, in this particular case, the school, this writ petitioner school was provided with 7 bighas out of the total land of 12 bigha 4 katha 8 less. That 12 bigha 4 katha 8 less was given initially to the agriculture department. And out of that, in the year 1979, 7 bigha was given to us because we were using it as a playground of our school children. And now, recently, they have created, the respondent side, they have created a land there of 2 bighas in the name of GMDA. But our total area was 12 bigha 4 katha 8 lesser, that is of the agricultural land. And 7 bigha was given to us, and 5 bigha 4 katha 8 lesser is with that of agriculture department. How in the middle they have given this GMC, this land of 2 bighas, and sometimes they are telling it is 2 bigha 2 katha 15 lesser. Some of the correspondence it is 2 bigha.
Understood, but Mr. Nandi, the question is, how do you take care of a situation where is your patta?
We have got this, if your lordship kindly peruse the document, that is, we have
Where is your
annexed
settlement?
this page number 56. May kindly be perused. That 58 is the original that notification by which we are given.
56.
56. 56 is the translated copy, the typed copy, and 58 is that original memo by which we were given this 7 less bighas of land, and remaining 5 bigha 4 katha 8 lesser, it will remain under dag number 388. Now, if my prayer is that if the dag number 388 is measured, that is 12 bigha 4 katha 8 lesser, then whole thing will come up.
So out of 12 bigha, they have given you only 7 bighas. Then what happened?
Bigha 4 katha 8 lesser is with the agriculture department. So now, in between, in the agricultural land and that of the school playground, how the GMC comes up in between us.
No. You show me why you are aggrieved.
Because
Sure.
first of all,
Which
they
order
have
you are challenging?
reduced this thing land.
Which order you are challenging?
My lord, recently they have given this 20, I have annexed it as annexure number 20, page number 122, where they are contemplating to give the 2 biggest plot of land to the page number
122.
122. Yes, my lord. That correspondence is given and copy is given to us that it is going to give this respondent number 9 and 10.
2 katha 10 lessers to vegetable market out of so and so measuring 2 bighas.
Yes.
Of here. Then how are you agreed?
Now, my lord, where is that 2 bighas and where from this
2 katha 10 lesser.
katha 10 lesser will be given?
Out of that 5 bighas,
5 bigha is never given to the GMDA, GMC.
they give it. Only thing is that your 7 bighas should not be disturbed.
7 bigha is not
Thereafter, you have no right.
my 7 bigha is not there. My 7 bigha, it is not there in the that order, my lord. It was already observed that my 7 bigha has been reduced to 5 bighas something.
Where?
It is in page number, my lord. Yeah, page number 98 may kindly be filled. That my tag number in that circle officer will pass a detailed order as specifically dealing with as to how the land tag number in that tag number 337 is reduced from 7 bighas as shown in the draft cheetah to 5 bigha 4 katha 14 lessers as referred to in his report dated 23/7/2015. Entire problem is coming, my lord, this 388 dak, which comprises the total area of 12 bigha, 4 katha, 8 lesser, that is not measured. If that is measured, the whole thing will come up.
You have been given in 388 or 338?
My land is 337.
No, 388. No,
GMC land. They have given.
no, kindly come to page 58. It is 388.
My lord,
It is 388.
my lord, 388 is the remaining land.
You have been given 7 bigas from dag number 388.
Yes,
Then
we have been, that is, my prayer is that if 388, that dag is demarcated, then the whole thing will come up. So very,
have you asked for application for demarcation?
my lord, we have repeatedly, we have prayed for,
Where?
before the circle officer,
Where?
that you,
So, where? Repeatedly, where? This is the land which is going to be given is 338. It is 338. Your land is 388.
my lord, my land is out of 388, the plot of land area measuring 7 bigger was taken out and it has been created at 337.
Where?
My
Show
lord,
me there.
my lord.
There will be a cheetah.
My lord, Chitha they have created, it is in respect of the Handy College.
Then you don't have
It's
any,
not Handy
there
College.
is no recording of any, there is no the record of rights. You don't have any record of rights.
Lord, only this memo is there. These are the memo. The government notification that is there.
No, there is no record of rights. In 1976, this has happened. When did this happen? 2019
My
or
lord.
79?
In the year 1979.
79, this has happened, and till date you don't have your name in the record of rights.
My lord, this record is just, they have as it is maintained by the notifications only.
No, it can't be like this.
My lord, then
No, no.
I may be given some time. I will place whatever is
Very
there,
well.
I will place. My lord. I'll place everything.
Next month,
My lord,
next month.
next month maybe given.
We'll have it in the month of October,
It will be
23rd of October.
23rd. Let it be.
At the request of the learned counsel for the petitioner matter stands adjourned to be listed on 23rd of October 2020.
Deeply.
Yes, it is also. The rejection of my candidature for retail outlet dealership, not the subject matter in. They have rejected on the ground that co-owners have not executed lease deed. This is factually incorrect, Lordship. Lordship may kindly take up page 38, Lord, email dated 29 December. And page 40 would be the relevant portion. Page 40 is the relevant portion.
Where is the impugn order?
Impugn order, Lord, would be at page, Lord. 84, Lord. 85 is the relevant portion. 85. 85. 84 is the email, 85 is the.
But to your application, please also refer to the letter dated when to submit certain documents.
Reasons is the all co-owner of offered land have not executed lease deed as per so and so
Thus, this is stated invalid, my lord. This is factually incorrect, maybe the document that we have submitted, my lord. That is our
Okay.
mistake.
Where?
Lordship may take a page 40 for a moment.
Where?
Five, this was the document, then document they are working, the Kharsa, Khatuni or any other equivalent revenue document or certificate obtained from revenue official confirming the status of ownership as on the date of the application, my lord. We submitted, my lord, in terms of this, my lord, we submitted document, which is lordship will find it, page 50 and 51, my lord.
Mr. Counsel. Mr. Counsel, there is a dealership, retailership, distributions outlet. Wherein it says that if the land is a ownership land, then you are to submit some documents, not these documents. There is some undertaking to that effect that they have no objection to them, something like that.
Lordship,
That's
that
the
is-
reason why it has been
But
done.
whether there,
Matter
that we have
ends.
annexed, my lord, we have annexed.
Did you give that document or not?
There is no.
Matter
co-owner.
ends out there.
No, my lord, there is no co-owner, my lord, that is the document, my lord.
What?
There are no co-owners in the plot, my lord.
There's no owners. You are the sole owner
Of the
of
plot,
which
my lord.
land?
Lordship may kindly see page 82, my lord, for a moment. Page 82 and 83. my lord.
Which land you have provided? Let's see your application.
Lord.
I say, but there is no boundary, madam.
Well, let us see. his
My lord,
application.
there is a trace map which has been provided. my
No,
lord.
no, where is your application?
Lord, application is, my lord, at page number 27, my lord.
Page 27.
Sorry, not 27, my lord, 29, my lord. 29, my lord.
This is your application.
Lord.
And
And page 40 is the land details, my lord. Page 30, my lord, 30.
serial number, which land you are offering here. Copy of the ownership of Iman, so and so, Rubin Das, their relationship to the applicant, shall registration give it 19/9, so and so, dark number, so and so. Okay. Now, where is that land? Land is of 19/9/2023.
The document that we have annexed is page 82, 83, my lord.
Where is the 19/9 document?
Page 52, my lord. And 57.
This is that.
52 is
Please.
the.
Indenture of lease of 19th of September, yeah, so and so, and Praveen Das, whereas the lessor is the absolute owner come patadar and under the exclusive possession of so and so, desirous of lessee so and so, and further has approached this court and accordingly so and so, so and so. The monthly rent will be 10,000, initial period of layoff will be leased with 30 years and so and so. So you have the 30-year lease.
Not sure I have.
Then what
And
other documents are
Page
required?
80,
Mr.
page 82, my lord, may kindly.
Huh?
Page 82, my lord. 82 and 80. Now, this is a land holding certificate issued from the Gosaigaon Revenue Circle, my lord. It says that last line, there is no other co-owner of the scheduled plot of land, my lord.
Huh?
There is no other co-owner of the schedule of the aforesaid plot of land.
How do you know?
Page 82, my lord.
Where is the lease deed again? I'm not familiar. Yes.
Last page 82 and 83, both, my lord, certificates. And in the mail, they have said.
Wait. Barsa Hada, son of so and so.
One bigger, one better.
There are two persons whose names are
Yes,
there.
sir. All the.
Barsa Hada and Samsud
And both of
Hembron.
them have executed lease deed. Both of them have executed lease deed.
Where? This is one at page 53,
Lord.
52. Where is the other one?
57, Lord.
Huh?
57. Page 57.
So both of them have executed the lease deed.
Both of them have executed.
But then
And Gosaigaon Revenue Circle has certified that they are the absolute owner of the plot of land. There is no other co-owner. Even this, and if your lordship has seen the order, my lord, no reasons have been given why these certificates have not been taken into consideration. They have rejected my candidature. This is the case. There is Jamabanti also that we have annexed, my lord. Order is also there, my lord, which says that I have the honor of this plot of land.
How did these two persons own it?
Purchase, my lord. Page 92, my lord.
92.
Page 92. Column number 2, my lord.
Hello.
As per field mutation order dated so in 2007 of circle officer, land measuring 1 bigger 1 kata 5 days of dark number so it meted in the name of Samuel Harbom, late son of so and so, and land measuring 1 kata dark number so and so meted in the name of Bertha Hatta, son of so and so, in the place of patata number so and so by way of purchase.
Yes.
Can you see?
And lordship, if
So what is the land actually requirement?
Hmm?
Dimension of the land, madam. Is requirement 1225 square meter, madam. This frontage is 35 and that is my 35. Is equal to 1225 square feet, madam. And one lesser miller has given me 1100 square meter only, madam.
What?
Kindly see the affidavit shown by the lesser miller, page 66, madam.
8?
66, madam. Now a page 67, madam, the lesser miller, Borsa has the miller, he has given me 1100 square meter. madam.
But this is not the ground on which you are rejecting.
Yes, my lord.
Then-
Well, kindly see the
No, no, you cannot do that.
but the-
How can you reject on some other ground? You are showing some other ground. I'm only on this, the ground
But
here.
you see, they are a co-owner, my lord. They have not executed the lease deed, my lord. The both the person have not executed the lease deed.
They have executed 2 lease deeds.
But that is not our requirement, my lord.
No, 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 no. The thing is like this. Both lands are contiguous and these are total 2 bighas of land,
Yes, ma'am.
of which one, as per the mutation records, 1 bigha belongs to one and 1 bigha belongs to the other.
Can you see the lease deed, but there is no boundary, my lord. Page
No,
57, my
you should have said that the lease deed
Yes,
is
ma'am.
not
Can you
in
see, ma'am?
order.
that was not the ground they have rejected.
That is not the
And they have
ground.
given it
But-
place map also. my lord.
Oh, without having the, my lord, boundary, my lord.
No, no, then you, if it, that is, if it is without boundary, then you take it up.
But we have asked for documents, but he did not respond, my lord.
Where did you say?
Yes, my lord. For a moment, kindly, page 56, my lord.
Hmm.
This is cellular property only, my lord. There is no boundary, my lord. 56, my lord. Borsa has the, my lord. This is one of the lesser, my lord. And second one is, my lord, page 57, my lord.
No, where is your document? Did you
Yes,
ask
madam.
for that?
Yes, my lord.
Because he has given this proposed
Now,
form
my lord,
as
this is,
annexure
page
13.
71, my lord.
Huh?
Page 71.
Yes. Notarized affidavit by the applicant, as per appendix here, proof of so and so, copy of the land agreement, so and so reason. Revised essay to be submitted with correct clause 12D. What is 12D? Please submit affidavit correcting the correct date
The
of
date of
birth
birth,
and mismatch.
second one, kindly
over
submit
here.
lease deed executed by
Submit
all
here
owners of
executed by
apartment, so-
co-owners of the offered
Now,
land. owner
kindly see the
recording
rejection order, page.
So where did you ask that it doesn't have boundaries?
It was,
You did not ask that.
But we have asked for the lease deed to be executed by all the owners, but he did not respond, my lord. Page 84, kindly.
We
see, my
set aside this thing.
lord. Now, kindly see page 84, my lord.
No, we set aside this. You do and carry out a fresh exercise. Give all these things. Why you not giving it? If you have any other good reasons, I'm not asking you not to do it. But on this ground, what you are submitting
Yes, ma'am.
is contrary to what it is, because it says unless you can bring it within the ambit of this.
Page 84, kindly for a moment, kindly see, my lord.
Yes.
What is the language that they have used, my lord?
Please refer to your application. Please also refer to a letter where you are advised to submit certain documents. However, we have not received
Yes,
any
ma'am.
response and required documents
not
from
claiming,
you
ma'am.
within the stipulated time. Now kindly see the reason. Where do you put the reason? All owners of the apartment have not executed the lease deed,
Yes, ma'am.
and as per DSG, this is, I think, the dealers for area,
Yes, madam.
clause 4A, such lease deed is treated as invalid. What is that? Let
Yes.
us see, let's see.
Page, my lord,
Clause
Right, in the
Bottom page
requisition
five,
also
my lord.
page 107. my lord. Cross your-
clause 4, page.
page 5, my lord, at bottom, my lord.
Huh?
Page number is given at bottom, my lord. Page 5, yes.
What is the page?
Page 5.
1,
5, my lord.
5.
Yes.
Only 5. Yes. What is that?
The other condition with respect to offering of land as under
Clause 4(6).
6 ml.
Where is 4(6)?
Bottom my lord.
What?
Page 5 my lord.
Page 5.
Yes, my lord. Bottom my lord.
No, this is a different document you are giving.
Page 106 document is there, when the repayment.
They have also annexed my lord. Page 106 man, they have annexed man.
A. A. Page 10.
106 my lord.
Relevant would be 107.
Other conditions with respect to the land should be available with the applicant as on the date of the application and should have minimum 19 years in from the date and after the date, but not later than. Okay. If the offered land is on a long-term lease and there are multiple owners, then lease deed should be executed by all owners of the offered land. In case lease deed is not executed by all owners, such lease deed shall be treated as invalid. But it is not a case that they are owners.
There is no nuts my lord. And listen,
Can't be owners.
But-
How can, just for example, how can two persons together who does not have, they have already otherwise partitioned their land? Patta is may be same, the dark may be same, but they say that, okay, you both of the, he give a lease in respect to this.
so they, the certificate given by the my lord, revenue officer 82 my lord. 82 my lord.
Yes.
So I have to defend my. Page 82 my lord. This is the report given by the cycle officer. my lord.
No, prior to that, see that other document he showed now, where is that mutation records?
Yes, my lord. Page my lord, 92 my lord.
92.
Yes, my lord.
Yes, this is very relevant. Was this document given to you or not?
Yes, my lord.
You see, one person is
But it
has
says, madam-
1 bigha, 1 katha, 5 lecha, other has 1 bigha, 1 katha, 5 lecha.
Yes, my lord.
So how can
Whether
a
they-
person,
Whether they have purchased my lord jointly or my lord severally my lord, that is not clear my lord.
you should have asked.
That's why my lord, as per these clauses, my lord.
So he is saying that I am giving you a conjoined plot of land. You may have very well said that lease deed has no boundaries.
Because, madam,
You did not
One
put
lease
that
does not
picture.
fulfill the
No,
requirement of my.
Mr. Waterpool, you did not ask those questions to me. Why don't you ask him those questions? Instead of keeping this matter pending out here and say, set aside this, take a decision, whatever may be, whatever you feel like asking. Or have you given it to somebody?
Already given my lord.
There the problem is. Already given mean how?
But
When
now
you
the
give?
scrutiny is going on my lord. Scrutiny is going on now. That's for us.
Scrutiny is going,
Yes,
not
madam.
given till now. Then I set aside this. I set aside this and asking you to do it, then you do it afresh. As of now, you have not given it to anybody. Have you given it?
No, my lord, the proceeding is going on my lord.
No, this is such a-
Verification is going on my lord.
See, the question is, you may ask many questions. You may say even that these does not have boundaries and we are not satisfied. Anyway, you take those decisions. But you can't say this before this court unless this is a part of your reason. You can improve your document to them.
It's clear that very.
Because I may today fix it. Tomorrow, at the end of the day, that third party would also be greatly affected. I think the setting aside, you do whatever. Like. You ask how many questions you want, you do it. And ask Mr. H.S. Roy and let me come back in 5 minutes.
Selection of response number 3, my lord.
Hmm?
I will not set aside the selection of response number 3, my lord.
If the selection is not satisfied, how can they take a fresh call, my lord? If the selection is not satisfied, my lord, the order is not satisfied, how can they take a fresh call, my lord, upon their own order? There's already an order. Is there. They have also sent us an email to refund our money, my lord, that was deposited.
Who are the other respondents?
Because they are the participant, Milord, of in this process.
Hmm?
They have participated in the
They're not
process.
necessary party member because they are not selected.
They are not.
Lottery happened.
Yes, you are selected member and it is now strictly verification of the documents is available.
Lottery done.
Yes, sir.
So you have selected somebody.
That's one number 3, madam. That's why, madam, I pray, madam.
You
Why not?
should notice then state. Can't help it, no, because that has to be then, I have to hear him now. It was only the BPCL, only the parties would have been different, but with others, for setting aside without hearing them would not be proper.
Or madam, directly ask him to re-verify his documents, madam.
But you can't do
In the
it, no,
meantime,
now
in
the
the
problem
meantime,
will arise because he will have some right. He will have a right in view of the lottery. Notice making it returnable on. Get it served.
Yes, madam.
All these people.
Only madam, respond number 3, madam, because the others are not selected, but they are not necessary party member.
But they have participated in the process. Milord.
They are already out, madam.
Let
If
them
he is
be-
not selected, madam, then madam, they will come, madam. Now the respond number 3 are only the necessary party member.
As they participate, let them be served. If they want to come, let them come, Milord. Otherwise, it may go for non-gender necessary party. They may be not necessary, but they are proper parties in the matter.
No, they are no longer a proper party now.
Yes, madam.
In view of the selection of strike out the names of 4 to 7. Then the matter would be passed. Otherwise, for serving them, the matter will be unnecessary because as of now, they don't have any right. Issue notice making it returnable on 23rd of September. You can get it done. 23rd,
Yes, madam.
23rd of September, 2024. Mr. Ex-gratia appears on behalf of the respondent number 1 and 2.
20.
As such, extra copies of the petition be served upon him during the course of the day. During the course of the hearing, Mr. Ex-gratia had submitted that pursuant to the rejection of the petitioner by the impugned communication dated 9/6/2024. The selection amongst the group 1 candidates was held by draw of lots. In the said selection so carried out, the respondent number 3 have been successful. So, taking into account the above, taking into account the said submission, the learned counsel appearing on behalf of the petitioner submits that the names of the respondent number 4 to 7 may be struck off. Accordingly, the names of the respondent number 4 to 7 are struck off. Issue notice. As regards the notice upon the respondent number struck off, in the counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties before the registry of this court on the basis of the instant order by tomorrow. And on the basis of the memo of parties so filed, the registry shall make necessary correction in the cause title of the petition as well as also update the same in the CIS. In view of the above, this court issues notice only upon the respondent number 3. It is seen that the respondent number 3, the address of the respondent number 3 has been mentioned to be care of the respondent number 2. Under such circumstances, Mr. S. Bhottakur, when the counsel submits that he would be in a position to get the service of the notice effected upon the respondent number 3 through the respondent number 2. Accordingly, extra copy of the writ petition be served upon and another extra copy of the writ petition be served upon him during the course of the day. From the materials on record, it transpires that on 28th of June 2023, an advertisement was issued for appointment of regular rural retail outlet petrol pump dealership by the Bharat Petroleum Corporation Limited. Pursuant thereto, the petitioner participated in the said selection proceedings along with the various other persons. As the petitioner had no land of his own, he had taken on lease a conjoined plot of land from one Borsa Hasda and Samuel Hembron. And in that regard, 2 registered deeds of lease were executed on 19th of September 2023 in favor of the petitioner. For a period of 30 years. In each deed of lease, the land leased out by each of the lessors named above is 1 biga, 1 katha, 5 lecha each. It is also seen from the records, and more particularly, the record of rights pertaining to Dag number 203 or Pata number 33. Annexure. What is this annexure? Enclosed at page 92.
Annexure 22.
Page 92 to 95. That pursuant to a steel mutation order dated 11/9/2007, the circle officer had mutated 1 biga, 1 katha, 5 lechas of Dag number 203 in favor of Sri Samuel Hembron and another 1 biga, 1 katha, 5 lechas of Dag number 203 in favor of Sri Barsha Hasda on the basis of purchase. It is the submission of the learned counsel appearing on behalf of the petitioner that as each owner had 1 biga, 1 katha, 5 lectures of land in Dag number 203, that is Sri Samuel Hembron and Sri Barsha Hasda, both the owners separately executed the deed of lease, 2 separate deeds of lease. The same appears to be based upon records so produced. The same prima facie appears to be based upon records. Be it as it may, by the communication dated 8/6/2024, the application of the petitioner was rejected with the reason, inverted comma, all co-owners of offered land have not executed lease deed as per DSG 2023 bracket clause 4 Roman 6 bracket small a. Such lease deed is treated as invalid. Inverted comma close, page 86 of 85 of Power date. The learned counsel appearing on behalf of the petitioner, however, submits that the reason on which the application of the petitioner have been rejected is ex facie not tenable. Inasmuch as all the document, the lease deeds, in as much as each there is no question of ownership. Inasmuch as each of the lessor of the petitioner were owner of 1 biga, 1 katha, 5 lecture each. And as such, they had separately executed the deed of sale, lease, 2 separate deeds of lease. And this aspect of the matter is evidence from the record of rights which were also placed before the authorities concerned. He therefore submitted that the reason he therefore submitted clause 4 Roman 6 small a could not have been made applicable to the facts of the instant case. On the other hand, Mr. S. Bhuttakur, the learned counsel appearing on behalf of the respondent numbers 1 and 2, submitted that the lease deed, that a perusal of the lease deeds would show that there are no boundaries. He further submitted that as from Annexure 19, the land which was proposed by the petitioner in his application was a conjoint plot of land wherein there are 2 co-owners, and as such, there should have been 1 lease deed with 2 executed by 2 co-owners. He therefore defended the reason assigned in the impugned communication on the basis of the said submission. This court had given an anxious consideration to the said aspect. As regards the first submission of Mr. Botaku, the same cannot be a ground for rejection. The said contention cannot be taken by this court as that was not part of the reason for passing issuance of the impugned communication. However, the second submission so made on the basis of Annexure 19 would require an adjudication. Next. This court, during the course of the hearing, asked inquired with Mr. Botakur as to what is the present stage of the selection proceedings. He submitted that pursuant to the draw of lots, wherein
It's a bidding process, madam.
Huh?
It's a bidding process, madam. It's not.
not drawn. Pursuant to the bidding process, the respondent number 3 have been selected and his papers are being verified. This court is of the opinion that in the meantime, if there is any order passed, thereby granting the dealership to the respondent number 3, further complications may arise. Under such circumstances, in view of a prima facie case being made out and taking into account the balance of convenience and the irreparable loss, harm, and injury which may be caused, this court directs the respondent number 1 and 2 not to further proceed with the selection process, as well as not to grant any dealership till the next returnable date.
I'm okay.
Mr. Bhattacharya informed them by telephone. Later on, it should not be that he did not give that order. You are present.
Item 15.
May I please your lordship. Lordship, this is a matter relating to the same lordship time barred assessments. Lordship, this is 2017-18. And the lordship impugned order it is at annexure 10, lordship, page 72.
(27 12/2023).
Yes, your lordship, under section 73.
Why you are challenging this?
Lordship, because it is time barred, lordship, because they have lordship by way of notification number 9 of 2023, they have extended the time limit. Lordship, my contention is that extension of time limit has not been adopted by the state. Lordship, the state has not adopted the notification number 9 of 2023. So, lordship, since they have not adopted this notification number 9 of 2023, lordship, this they cannot pass an order of assessment by lordship extending the period of limitation. The lordship last date of passing the order of 2017-18 was lordship 21/2/2023. Because lordship, my date of assessment was lordship, the due date of filing the returns was extended. Now 3 years will be counted from the date on which last date of filing was given to me. The last date of filing was 7th of February 2020 for 17-18. So lordship, they could have completed the assessment by 7th of February 2023. They have invoked the section 168A of the lordship GST Act to extend the time limit by issuing a notification 9 of 2023. And Lordship, they have extended the limitation. Lordship, the central government have issued the notification, but the state government have not adopted that notification. Even though 168A was there in their Lordship, the GST Act, 168A have been adopted by the Assam GST, but they have not Lordship, issued this notification, neither have adopted this notification. They have not said that this is going to be applicable to them. They have not done both. So Lordship, they cannot Lordship take the advantage of the
So we can only state the state GST, not the central GST.
Lordship, central GST, Lordship, if we talk about 56/2023, 56/2023, 9 of 2023, Lordship, there is a recommendation.
56, forget about it. 56 does not relate to 1718.
17/88, it's not.
He says 9 is okay. 9 is, I'm satisfied with 9.
No, I'm not, Lordship, so far as 9 is concerned, Lordship, apart from that, that the state has not adopted it. Even thereafter, 9 is not, not
Only for state GST cannot be maybe state, but not the central one.
Lordship, but the
Yes.
force major is also there.
What force measure? Force measure is not there. That has already been settled by the two judgments. One is Kerala and other is here. I am satisfied with the reasonings given there. So 9 is okay, but
For 17/18 only this judgments were there.
17/18,
Kerala, High Court and
that is already been done, and
Lordship.
17/18 they have not. We asked them to pay that there may be coercive measures as against the central GST and IGST. They can take, but not against it.
Lordship, but the order has been passed by the state authorities. Lordship.
Who?
Lordship, whatever order they pass, Lordship, this is the order passed by them. The central has not passed any order against. The state has passed. This is the order passed by the state government. So Lordship, whatever
Why
order
is the
officer has
state?
passed,
I don't understand why the state is passing on the central thing.
Lordship, because Lordship, they cannot pass the order individually. They cannot pass the only the
No,
state
what
order.
is the authority being given to the state to pass on the central?
Lordship,
How the assessment of the central is being made by the state authorities?
because Lordship, the CGST and SGST part, they cannot pass the order under IGST, but CGST and SGST. Lordship, there is an interstate transaction, there is an intrastate transaction. So Lordship, if there is within two states, Lordship, the central only has the power under IGST. But Lordship, if a transaction is within a state, Lordship, then CGST as well as SGST will be applicable. So Lordship, the central portion, Lordship, they are divided into 50-50%.
How is the jurisdiction being given for the CGST to be done
Lordship,
by the state authorities? Where is the jurisdiction?
Lordship, the jurisdiction, Lordship, I'll have to see.
If that jurisdiction is given specifically and they exercise on the basis by any delegate out there, by the state exercise the jurisdiction, then they can very well do under the CGST. It will
They
be
could have
deemed
done
that
under
it has been
CGST.
done by that authority.
Ah.
But for convenience, it is being done by the state together.
The convenience the state has
So
passed on
then,
the-
why
But
not
Lordship-
this?
But
State-
Lordship, the CGST,
Why you pay these two? July, that amount of 1,49,000 and the other is IGST 48,000 and so on. Rest we stay only days.
Lordship, the
You're there? In this party?
Lordship,
What is your submission? What is your submission? Tell me, you cannot be just saying this court is not going to protect your rights. Not this court is not sitting unless you protect your rights. Tell me, what is your case?
I'm on 1 and 2 years.
Understood. You are not standing out here just to say that I am 1 and 2. You are here to say why you see, you have a notification. See her ground. Her ground is this. Notification number 9 of 2023 had come. This notification number 9 has not been adopted by the state and could not have been adopted because there is a power under 168A given to the state. So as of now, the state does not have a notification, then the state is doing this. But in what is happening that there are 3 elements by which the order has been passed. SGST, CGST, and IGST. IGST and CGST is normally to be done by the central government authorities. But there is a delegation being given to the state authorities to do so. Now, how do you say, because this, as per 9 of 2023, that has already been held by 2, 3 courts of the country high courts holding it, that is done in accordance. There is a recommendation, and that recommendation is also there in the 49 council. So there's no problem with that. On the question of force measure, that has been already taken care of. So this court is not otherwise satisfied with the challenge of 9. Okay. But her specific submission therefore is that look at 9 has not been done by them. Similar 9. So under such circumstances, the period ends on 21/2. But that can be only in respect to the state. The state's power is there only. They may not like, the state may say that, okay, we give away all this, we have too much of money. We now recently from the ONGC and the oil judgments out there passed by the 7 judges bench, the state has a lot of money. They can very well give it. But the central government for whom you are representing, they may not like to be so gratuitous or be so benevolent to them. What is your submission? And don't say that you are 1 and 2. What is the state going to do?
Lordship, on the last occasion, my friend in the other similar cases, which Lordship was fixed on 17.
That I know. This
yes,
also I am going to fix on 17.
Yes,
But what about that portion?
state Lordship is
Because those cases were all 56. The 56 is being challenged, that too without a recommendation. Here it is a 9. This is 17, 18. Here her specific submission is different. Says that maybe 9 is there, but this is this.
here,
So
Lordship,
therefore, the central government, what is your submission to that effect? How do you take care of that situation? Or you want to take the help of Mr. Kyle? Yes, Mr. Kyle.
After the amendment of 65, this section has been added. All the CC up to 2021, those who have filed their return up to September 21, they will be entitled to benefit under section
These are 16.4, 65.
16.5 is newly added,
I know that, but is this 16.4?
probably. Actually,
These are
is
not
not- this is-
16.4.
this
These
is
are
not-
what?
This is the Lordship levy of interest. Levy of interest. Levy of interest, Lordship.
Levy of interest is being taken care of 128A.
Yes.
No, Lordship, that has not been, Lordship, that has not neither been notified nor has been taken care. If I pay my taxes before that, then Lordship, the interest and this, Lordship, this has been passed, Lordship, the order has been passed and levying interest on me. Lordship, because I have filed the Lordship return a bit late. Lordship, my return has been filed after 2021. The date which has been given till Lordship, if I file the return within November 2021.
128A. Now,
If that is the case, they have filed return subsequently, then they are not entitled to benefit under this thing.
That is what in Finance Act, I'm not talking about Finance Act. Finance Act 16.5, the benefit is not applicable on me. That is why, Lordship, I am before your Lordship that I want that order to be gone because the interest has been levied on me. That interest is levied because I have filed the Lordship return after the due date which has been given, that is 2021. The due date is November 2021. So November, after November 2021, if I file my return, Lordship, I have to pay the interest part. The benefit is given to only those SSC who have filed their return November 2021, not any person after that.
let us see 128A,
Lordship, 128A.
Finance Act.
Lordship, before the Lordship 128A, the newly inserted Lordship 16.5, which is there, which has been inserted in the Act, of which Mr. Kyal was referring to. Lordship, this 16.5 says that if I file a return within Lordship November 2021, then Lordship 16.5 benefit is given to me. Lordship, amendment in section 16. in section 16, the CGST with effect from 1st day of July 2017. After subsection 4, the following subsection shall be inserted. Number 5, notwithstanding anything contained in subsection 4, in respect of an invoice or debit note for supply of goods or services as both pertaining to the financial year 17-18, 18-19, 19-20 and 2021, the registered person shall be entitled to take the ITC in any return under so and so, which is filed up to 30th day of November 2021.
Is a finance act.
Lordship, thereafter, clause 128A. Lordship have the copy of the Finance Act. Lordship. So, Lordship, under section 16(4), if I have filed the return within November, then Lordship, firstly, this benefit will be available to me. Secondly, Lordship, section clause 128A says that if I pay all my taxes before the due date, which is not yet been notified, which is not yet been
This
notified.
section is not notified.
Not yet
128.
notified. Not notified, Lordship. They have not notified the date from on which I have to make payment. Lordship, the thing is not still not very clear. Notification has to be issued now on the basis of the Finance Act which has come up. The notification has not yet been issued on 9th of September, Lordship. The GST
No,
Council.
notification has been issued.
No, Lordship.
What?
Finance Act, only Finance Act has come, Lordship. Notification has, they have not notified the date. This is the Lordship Finance Act. Finance Act has come, notification has not come.
On 16th October, sorry, August, Lordship, it has been notified. Of this in the
No,
official
this is
gazette.
that is a Finance Act which has been notified. The date has been not been notified by which we have to pay the taxes. Accordingly, then Lordship interest and penalty will be Lordship waived. That has not yet been notified. And there is still a confusion, Lordship, how the Lordship benefit they are going to give to us. Because the orders has already been passed. What will happen to the orders? Some of the Lordship SSE have withdrawn their cases, but Lordship, it is very difficult to say how they have withdrawn the case because the assessment order still remains. They have to notify what will happen to those cases in which order has already been passed. That has to be set aside, Lordship. Law has been laid down, that has to be implemented now.
Contained to the contrary contained in this act where any amount is payable by any person chargeable with tax in accordance with a notice under subsection 1 or demand statement made under sale and when no order under sale has been issued or an order has been passed under subsection 9 of section demand and where no, that is already given insertion.
No, Lordship, kindly read below. Pertaining to the period from 1/7/2017 to 31st March 20 or a part thereof and the said person pays the full amount of tax payable as per the notice or statement.
From 1st July to 31st
March 20.
2000 or a part thereof and the person pays the full amount of tax payable as per the notice or statement or order referred to in subclause AB as the case may be on or before the date as may be notified by the government in
Recommendation of the council.
No interest under section penalty of demand shall be paid.
Lordship, the
Provided that when a notice has been issued under subsection 1 of section 74 and an order is passed.
as may be prescribed.
74 we are not concerned. Provided that the Conclusion of the proceedings on the subsection.
as condition as may be prescribed in that notification.
In paid, then refund the proceedings.
Lordship, on the basic recommendation of the council, that notification has not yet been issued, Lordship.
They do one thing. They stay only that
Lordship,
as
because,
this.
Lordship, if the central officer would have passed this order, I would have not been, I would have been satisfied. That
You
state,
file appeal before division bench, very good. You have no, as of now, this is an order of 27/23/12/2023. You are coming in the month of August. You want to defer this matter till 17/9, I can do that. No stay, nothing. But otherwise, I may say that you are liable to pay.
Lordship, because the state officer, even though they have.
No, first, therefore, you have to show me how does the state officer, you see, getting an assistance from these officials, the counsels from the respondent is not the question out here. Here you have to show me that how does the state authority exercises the jurisdiction over SGST or CGST.
Lordship, when the SGST officer passes an order, he is entitled, he is empowered to pass an order under CGST also under section 6(1)(a) of the Lordship Assam Goods and Service Tax Act.
Assam,
Goods and Service Tax Act. But Lordship, Constitution I have to see, but section 6(1)(a) empowers the officer.
Assam kon go. Of officers of the state tax or union territory tax as proper officers in certain, without prejudice to the provisions of this act, the officers appointed under the State Goods and Service Tax Act or the union goods are authorized to be proper officers for the purpose of this act, subject to such conditions that the government shall, on recommendation of the council by notification, specify. If that be so, here the State Goods Assam's GST Act, these officers are being appointed.
Assam Goods.
So they can do for central as per
Central as well.
6(1).
Central as well. They have been empowered.
They are empowered by this. If they are being empowered by a provision, why can't they exercise that provision on behalf of the CGST where there is an extension given?
Lordship, because Lordship, because he is the officer who has not, because he is the state officer, Lordship, even though he has been empowered to pass any
Maybe
type of order.
the power is not of the state.
Of-
The power is, let's see, 168A. The power is to whom? Notwithstanding anything contained in this act, the government may, on recommendation or by notice, extend the time limit specified in or prescribed or notified under in respect of actions which cannot be completed or complied with due to force measure.
Force measure.
The power to issue is there. Now let us see if that notification filed.
9 of 2023.
Where is 9?
9. Lordship, page 71.
The best part is there is no 71 in my petition. Where is this type of petition?
I'm really sorry, Lordship. If there is some-
There is no
Should be given a
71
page.
here.
Maybe in the second copy it is.
Huh?
It is there, Lordship. I'm really sorry for this, Lordship. Please, give me.
No 71.
It may kindly be taken off also other day. I will, Lordship, improve this. This is a Lordship mistake on our part. May be taken up next week, Lordship. This matter may be kindly taken up next week. I will give 71, page 71. This is Lordship. I'm really very
The
sorry.
learned counsel appearing on behalf of the petitioner submits that inadvertently page 71, which is annexure
Eight, Lordship.
Annexure 8 have been left out. Full stop. She therefore submits that she may be permitted to file an additional affidavit bringing on record the said notification. Annexure 8. Full stop. Permission granted. List the matter again on 9th September.
Much obliged. I'm really sorry, Lordship.
Yes, do something. 168A2.
Process it on.
And you, both of you kindly come up with some solution out there, what you are not assisting the court.
Much obliged.
Item 16.
So earlier, we have mistakenly filed a CRP, Lordship.
Huh?
Earlier, we have mistakenly filed a CRP, challenging an order of a Assam Board of Revenue. Later on, we filed a IA, and we were allowed to convert the CRP to WPC, Lordship. Order at page 21, Lordship.
Then
And accordingly, we have filed this WPC. So notice may be issued and that CRP may be taken.
registry on the basis of filing additional pleadings and convert the revision to a petition 1226. The matter will be established. Then, now tell me what is your case? It's not so easy. Don't think that the court is such an easy thing. Where is that document order? The main issue from which the dispute starts is the sale of the land involved in auction number. This is the appellant claims to have been set aside. The impugn order shows that the sale has not been set aside. The appellant could not give any evidence to show that the sale has been set aside. All the litigation thereafter, whether before the age or the year, is not relevant so long as the sale remains valid. Tell me, sale has been set aside.
Challenge the Lordship, then.
Have you challenged the sale? Have you challenged the sale? The auction sale?
Yes, Lordship.
Where?
Lordship. In the year 88-89, Lordship, we challenged that.
Where?
And
Which is the order?
order, maybe it's tagged with CRP, Lordship. With LCR tag with CRP, maybe, Lordship.
You have to file properly. Not the manner you are. This is a writ now.
Yes, it may be tagged with the CRP.
Now, why will you take without issuance of notice?
The notice may be.
You
also-
file your additional affidavit bringing on record those documents. How are you filing this?
We don't have the 88-89 record, Lordship. Right now, we do not have 88-89 record.
Huh?
We don't have the record, but we have the stay order in CRP, Lordship.
Forget about the stay order in CRP. That is, CRP has gone for a 6. CRP is not maintainable. I have asked them to convert it.
Yes.
Unless you bring, this is a writ petition. Now it has been registered, recently registered. So now it has to be registered and this court has to issue notice. Why will this court? And why you are making the chairman, Board of Revenue a party? Goodness.
So
You
we-
can't make that.
the challenge
Have
is-
you ever seen the Assam Board of Revenue Act? Have you seen that? Have you seen that?
We are challenging the order, so. we-
Mr. Counsel, have you seen the Board of Revenue Act? First you go to yours.
That's why I may be correct. The same.
How much time you require? 2 weeks?
2.
You file an additional affidavit bringing on records, the record of the CRP. The what you have filed. That is one. Second, you have to look into it. You have to correct it. It cannot be, you can't make the judicial officer or an officer a party. You are making Assam Board of Revenue, you can very well make an Assam Board of Revenue, but it has to be represented by the secretary.
Secretary, we wrongly put as chairman, Lordship.
Tomorrow, if you make the Guwahati High Court a party, are you going to make the Chief Justice? Whom are you going to make? Whom are you going to make?
Registrar, Lordship.
Register General. So this is how you do it. At the request of the learned counsel for the petitioner, place the matter to 2 weeks.
All right.
Mr. Rajendran, we fixed this matter on 17/9 and passed a
Lordship.
similar order. We
Lordship.
There are no coercive measures as regards that order of 30.
Lordship. Order dated is, my lords, 30th April 2024.
Oh, yes, we stayed that order. Right?
Lordship.
Okay,
Lordship.
ask your junior to make the service upon them.
Lordship, I'll inform my lord. It's lordships are keeping on 17th of September, lordship.
17th of September with the other.
I'll appear physically, my lords. I'll assist your lordships.
Yes,
On the earlier
And
matter also, my lords.
You also help this court. You see, one of the earlier matters I was just taking up. You see, in Assam, what is the biggest problem which is happening in the state of Assam have not come up with a similar notification, which
Lordship.
have been given like 56 or 9, which have been given, there is nothing, no notification. Now, can it be a case of, now the power which seems to have been exercised by the state officials is under section 6(1).
Lordships.
CGST Act. If that be so, can it be bifurcated? Can the order be segregated in respect to the CGST and the IGST taken out and only the SGST may go? Just for example, tomorrow I don't set aside this, 56 is not taken, but 56 is held to be good. Then how do you take care of this situation? What will happen to the state CGST and the GST as well as the central GST? Because then central GST will be within the time period, but the state would not. Just come up prepared with
Lordships,
understanding.
I'll assist your lordships. My lord, your lordships have raised a very, very fundamental question.
Yes.
We are also grappling with the same issue, whether the officer authorized under both the statutes
No.
passes an order, whether in law there are two orders passed under two acts, or it's a common order where the officer exercises jurisdiction qua a single supply. There is a single supply which attracts section 9 of the CGST Act as well as section 9 of the Assam GST Act. Lordships. Lordships have raised a very fundamental question, my lords. I'll make an endeavor, my lords, to be there and assist your lordships on this point, my lords. Certainly, my lords. Grateful. I'm obliged, my lords. I'm obliged.
17.
Your lord, as for official, I have taken steps yesterday, your lord. Means
Steps upon whom?
respondent 5 and 7.
As per Honorable Court, petitioner was directed to take steps upon respondent number 5 and 7 by registered post, but no steps have been taken for issuance of so and so. 5 and 7 is who? 5 and 7. What is
Actually,
your case?
initially we filed for respondent number 7, it was represented by Mr.
What is
J.
your case?
It is a case.
Directing the
Your-
respondent to immediately grant departmental approval to the
Approval.
water user committees of 13 numbers of 5 water schemes with constituted by the petitioner as the president and so lines under so that the DWBs will be immediately operated from the.
In the
What
meantime,
is
your
it?
lord,
This is something like day before yesterday I was taking a matter. Day before yesterday, yes. There was a case fight between two factions whom you have on the basis of some scheme the PHE gives. Is this something like that?
But this concerns about formation of the committee, the water users committee.
Who then supplies it to the end users?
Yes.
yes,
But lot
They
of it is
monitor.
comprised of the users itself. That is why lot
Huh?
it's called, it is comprised of the users of the locality. That is why it's called water user committee.
No, there in that case there was a fight between two authorities. One was one person saying that I have been given, the other person saying that I have been given out. at the end of the time, what is happening is the end user is being affected because the petitioner is saying that, look here, that response number 7, 9 to 11 is cutting my pipelines.
Yes. It is not in this case.
That is a different issue, Lord.
Yeah, what he wants here. What do
Here
you
your
want?
Lordship, 13 numbers of PWSS, a water user committee. In the meantime, they have already granted approval to 4 committee, your Lordship, water user.
Huh?
In the meantime, out of 13, they have already granted approval to 4 committee, water user committee,
Ah.
and there still remains 9 committee.
Then,
Your Lordship, as per the guidelines, the committee are formed by the Gaon panchayats and local people. And after constitution, that is sent to the chairman. District commissioner is the chairman and the executive engineer is the secretary of the committee. They grants approval. And as per, after laying the infrastructure, it is the user committee who monitors, manage the piped water supply scheme, your Lordship.
so what do you want now? Oh, you are not interested.
No, I am interested.
Then why
The
haven't you
remaining
taken
9
steps?
no, steps I have already earlier taken.
Yeah.
Actually,
It has been
respondent
submitted
five
by the
was-
learned counsel for the petitioner that the steps have been taken yesterday. To list the matter after completion of. Still, we are not interested.
No, I earlier have taken step, but it was up to government council. Oblige, your Lord.
May I please, your Lordship? Lordship, I am here against the impugn eviction order, Lordship. It is at page 39, the translated copy. Lordship, I am the possessor of a land measuring 2 Katha 11 Lessa under DAG number 896 under the Sapor Revenue Circle of Kajipara Part 1 Village, Lordship. Lordship, in the year 2010, I have been
Water
granted
bodies.
the settlement proposal.
You are in water bodies.
Lordship, it belongs to the category of water body.
Then
But Lordship, I am residing there since long back, and settlement proposal of the land has also been approved in the meeting in the year 2010 itself, Lordship, but nothing has been done.
What-
17 is the
Water Bodies Act came when? When did the Water Bodies Act come? Hmm? No, page 37 is what document?
page 37 is a notice for hearing, Lordship. They were asked to appear for hearing along with all relevant documents that was issued by the
But
circle.
these are different persons.
No, Lordship, the same person, Lordship. One of them is the petitioner, Lordship. They belong to the same family, Lordship. And Lordship, pursuant to the said notice, the eviction notice has been issued, Lordship. Order has been issued. Lordship, my stand is,
Katha 11 lectures.
Lordship,
Kajipara Part 1.
Lordship, my stand is that nothing has
It
been
is,
stated.
it is under, it is given in the Water Bodies Act.
Lordship, I'm not aware of the act, Lordship, right now.
Huh? Then why did you go ahead with the settlement proceedings?
Lordship, that has been done in the year 2010 proposal, and afterwards there were several communications also. So they were in the hope that that will be granted settlement. And Lordship, the interim eviction order stated nothing regarding the region or the cause why they will be evicted or such.
Government land.
It is a non-speaking order.
land.
But there is a settlement proceedings.
Lordship,
State file your affidavit. To notice making it returnable on. How long? Issue notice returnable on 25th of September 2024. Ms. P.R. Mohanto appears for respond number 1. Mr. N. Goswami appears for respond number 2 to 6. The petition, as the respondent numbers 1 to 4 are duly represented, extra copies of the petition be served upon them during the course of the day. The petitioner herein is have assailed the notice dated 19/8/2024, whereby the petitioner have been directed to vacate the land within 3 days from the date of receipt of the letter of the notice. It is further seen from the impugned notice that there is a mention that the land in question is a government land under dark number 896, measuring 2 kata 11 lectures of Kajipara, part 1. This court have also perused the materials on record, more particularly the minutes of the state level. What is that? State
Subdivisional Land Advisory Committee.
Subdivisional Land Advisory Committee meeting held on 24/12/2010, wherein the settlement proposal, the settlement application submitted, the settlement proposal of the petitioners have been approved subject to deposit of due premium. In addition to that, it is also seen that the respondent authorities were taking steps for fixing the premium. And it is under such circumstances, fixing the premium. And the last of such document is dated 5/8/2024, as could be seen from Annexure E. Be that as it may, on 31/7/2024, a notice was issued asking the petitioners calling the petitioners for a hearing. It is not for a hearing on when,
On the next day, Lordship.
where,
Lordship,
Lordship,
page 37 is the translated copy, Lordship.
where it is said on in the
You
morning.
were directed to show cause on the aforesaid matter and appear in the office at 10 AM in the morning along with all relevant documents.
the vernacular is Ohakali.
Ohakali, Lordship, the next. In the vernacular, Lordship, I find.
Was asked to appear on 1/8/2024 for a hearing. And thereupon, the impugned notice was issued on 19/8/2024. Taking into account that the petitioners have been residing in the said land, more particularly in dark number 896 of village Kajipara, part 1 of, what is that area?
The Sapor Revenue Circle, Lordship.
Huh?
Sapor Revenue Circle.
Part 1. What is the full
Kajipara.
address?
Kachipara, part 1 of Sapor Revenue Circle.
Comma. This court is of the opinion that some protection has to be granted to the petitioner pending disposal, till the next date. Inasmuch as otherwise the instant writ petition would become infructuous. Accordingly, this court states the impugned notice dated 19/8/2024 till the next date. It has also been submitted that by the learned counsel for the petitioner that till date, the eviction proceedings have not been initiated. In that view of the matter, Mr. N. Goswami, the learned counsel appearing on behalf of the circle officer, Sapor Revenue Circle, is also directed to inform the said official during the course of the day by way of a telephone not to initiate any further proceedings for eviction on the basis of the notice dated 19/8/2024 till the next date.
Much obliged.
You informed him.
Yes.
Later on, it should not be that after order they have demolished it. Which notification you are challenging?
It's in page 23, Lordship,
Huh?
23.
What does it say?
Okay, it's in person to the Lordship 20s of the Wildlife Protection Act, Lordship. It's like the area, the scheduled area, which is in page.
Yes, why are you challenging this?
Because upon this, the Lordship, my area where I'm, the residents are, Lordship, there is a apprehension that there will be a eviction, Lordship.
Huh?
And there will be eviction because it is declared as a sanctuary, Lord.
It is declared as a sanctuary under what provision?
The Wildlife Protection Act. Lordship.
Okay, now Wildlife Protection Act, this happens in terms with section 35 of the Wildlife Protection Act. If it is done under 35, there is a acquisition proceedings in terms with section 36, which categorically mentions that the proceedings will be parameterial with terms of the Land Acquisition Act in 1894. And the moment the notice has been issued out here, it becomes a part of it. The land vests upon the state.
So the notice is not yet issued, Lordship.
What notice? This is a notification of
Yeah, this is
19th of June.
notification, but personal notices are not issued, your Lordship. That's why our prayer.
Why
is-
personal notice is required to be issued? Have you seen section 35 of the Wildlife Protection Act?
That's what, Lordship. That's why the matter was tagged with the PI, Lordship.
Forget about the PL. I'm not concerned. This has been detected. We're not concerned with that PL business. Here is a case where there is a notification. There must have been a notification, initial preliminary notification, which is given out there as per 35. Then,
Lordship, actually, Lordship, my point is to say, Lordship, there is a resettlement process is going on, Lordship.
what is
regarding-
resettlement
regarding the survey-
proceeding? There
regarding-
cannot be a resettlement proceedings. It is a forest area. It has been already been declared.
Yes, Lordship, but there is surveys going on, Lordship. to-
There cannot be a survey by the revenue. Do you know why?
It's between the Survey of India and the.
Why? There cannot be a survey by the revenue authorities, taking into account that section 4(1) of the regulation categorically says that forest land is outside. This becomes a reserve forest in view of this notification.
But still, Lordship, the boundary issues are still going on. That's why, Lordship, Survey of India has to come in, Lordship, and to demarcate the
Boundary?
forest area.
What boundary? No, it will once it is being declared. It has been declared on meets and bounds on the basis of dark numbers. Isn't it, Mr. Bothakur?
The coordinates are given, the case
That's it. Mr. D.J. Das, the learned counsel appearing on behalf of the petitioner, is not prepared in the matter for which the matter stands adjourned to be listed again on when? 17th of September 2024.
Yes, is your Lordship. Lordship, petitioner wants to withdraw the petition, Lordship. Petitioner wants to withdraw, Lordship.
The learned counsel appearing on behalf of the petitioner submits that she has instructions that the petitioner wants to withdraw the instant writ petition. So taking into account the above, the instant writ petition stands closed on withdrawal. Interim orders, if any, stands vacated.
Item 20.
Wait, please, your Lord.
Hmm.
But in this matter, my lord, we have issued notice to the IRDA, my lord. IRDA has appeared non-payment of awarded sum, my lord. For cancellation of license, we started the process, my lord.
What?
There- Non-payment, we filed a MSC case, my lord. In the MSC case, there was judgment, my lord. Page number 11, my lord, the judgment. Award was passed. For 3 months, it was not paid, my lord. Amount was not paid. We approached the IRDA.
That is at page,
Where?
it will be at page 19, my lord.
Huh?
Page number 19, my lord, next to.
Ah.
For initiating of process, my lord, the idea has appeared, my lord, they have not filed any. Thereafter, my lord, they have deposited.
How do you know that you have sent it?
Lord, there is a postal receipt and.
Yeah, doesn't mean that these have been reached by these
My lord, we have
authorities.
made a statement.
Yes, Mr. Dutta, have you paid the money?
Yes, my lord, award was paid thereafter.
Oh, matter closed.
It's by the insurance company, my lord. We have
Huh?
for IRD.
Anyways,
No,
the
only-
money has been paid.
Money has been
We
paid.
close this petition.
Lord, sir, only one.
Day, don't come up with all these things.
Sir.
Some other day, some good matter is there. In that matter, I've given you the liberty,
Sir.
then they don't pay, then you come up.
Sir.
You want something?
Sir, let me allow to withdraw it, my lord.
Yeah. Mr. Elal, the learned counsel appearing on behalf of the petitioner submits that taking into account that the amount has already been paid, the awarded amount has already been paid. The awarded amount in terms with the judgment dated 22/11/2018 by in MAC case number 766/2015 by the motor accidents claims tribunal, learned member motor claims tribunal number 3, Kamrup Metro at Guwahati having already been paid. The petitioner would.
Look, half of the award has been paid, my lord, they have preferred an appeal, so it is still, half of the state.
No, appeal has been filed.
They preferred an appeal, the insurance
okay.
company has
And
preferred
again,
an appeal.
Mr.
Half of
Mr. Elal, the learned counsel appearing on behalf of the petitioner submits that in view of the fact that 50% of the awarded amount has been paid in terms with the judgment dated 2/11/2018 passed in MAC case number 766/2015 by the learned member motor accidents claims tribunal number 3 and the remaining has been not paid on account of a stay being granted by this court. He would not like to press the instant writ petition. He, however, submits that in the circumstances a need arises at a later stage after the judgment passed by this court. He may again be permitted to approach the appropriate authorities. Taking into account the above, the instant writ petition stands closed on withdrawal. However, liberty would be there to the petitioner. So, liberty is there to approach the appropriate authority if after the judgment passed by this court, there is any infraction to the Insurance Amendment Act 2015.
We are appearing for respondent.
Give your names.
Obliged.
Your Lordship, the matter has come up after a long time. I'm seeking for some time to get instructions regarding the current status of the estate, Your Lordship. The petitioners were aggrieved by the inaction of the respondent authorities.
Now, have you been given the security?
Your Lordship, I'm praying for a short accommodation to know the current status.
Okay, at the request of the learned counsel for the petitioner, matter stands adjourned to be listed again on 11th of September 2024, so that she is in a position to provide appropriate, she is in a position to obtain instruction as to whether the order dated 27/3/2019 passed in the instant writ petition have been complied with. Mr. N. Goswami appearing on behalf of the respondents, more particularly the Superintendent of Police Kamrup, shall also apprise this court as to whether the order dated 27/3/2019 have been complied with. And further to that, as There's a registered FIR?
FIs were registered.
In such cases, we have filed affidavit and that FIR, we have FIR has been filed. The
FIR has been filed.
File affidavit. There are 5 over affidavit.
Okay, nothing immense. Heard Ms. So the learned counsel appearing on behalf of the petitioner and Mr. N. Gusami appears on behalf of the respondent state. The petitioners herein have approached this court seeking, being aggrieved by the lack of proper investigation being carried out in connection with Baihata PS case number 51/2019 and Baihata PS case number 58/2019. In addition to that, the petitioner have also sought for that proper security be provided to the petitioner. First, this court have duly taken note of the affidavit in opposition filed by the respondent number 3, wherein it has been mentioned that both the FRs, both the cases, both the cases which have been registered as Baihata PS case number 51/2019 and Baihata PS case Sariali case number case number 58/2019 have been duly investigated and final report have been submitted on account of insufficient evidence. This court have also duly taken note of the communication issued by the Superintendent of Police Kamrup Amingam dated 1/4/2019 pursuant to the order passed by this court on 27/3/2019. So taking into account the above, nothing further survives in the instant writ petition. Be that as it may, the petitioners herein have duly can always avail other remedies as provided under the extant laws.
May I please your lordship? My senior Mr. Sharma is legs before another court. May kindly pass over the matter for the time being.
What are you asking?
Also, what happened is, my son went missing, your lordship, and he took a loan from the Axis Bank. And till that he is untraced, your lordship. He remains untraced.
Huh?
It is almost 8 years now. So presumption of death may also be been drawn, your lordship. But in your lordship, Respondent Bank instituted a surface notice, your lordship, and I challenge that notice, your lordship here.
Did you file an affidavit
Yes, I have filed it,
pursuant to the order passed on 26/7
lordship.
that there is a proposal going on?
But then today itself, I got a reply from the bank, your lordship.
Ah,
It has been sent by WhatsApp to me, your lordship, by the
okay.
petitioner,
It
your
has been
lordship.
submitted by the learned counsel appearing on behalf of the Axis Bank that certain instructions will be required in the matter. So taking into account the above, list the matter on 30th of September 2024. Interim order passed earlier shall continue till then.
Much obliged.
Apologies.
May I please, last order dated 7/8/2024 may kindly be seen.
Why are you asking for money?
Because land and the Girard land was acquired by the deputy commissioner.
Where is the acquisition?
Yes, acquisition is not specifically mentioned, but lordship kindly see at page 16. There is a details of Girard and structure of page 16, my lord.
What is that?
here my lord, only my lord, total value assessed my lord, 57,448.
Then what do you want?
Now, my lord, we my lord, made representation before the competent authority, lordship will find at page 24
Then,
for my lord, proper assessment of the Girard, page 24, my lord.
then,
But no action has been taken on the,
have you received any amount?
no amount has been paid.
Now, has there been any acquisition proceedings?
That information is not available, my lord.
No acquisition. Yes, government, you have been asked to file affidavit, why you are not filing it? Huh? There was a direction to file the affidavit on appearing for 3, 4, and 5. Let us have the personal presence of these 3, 4, and 5. The deputy commissioner, additional and circle officer. Let us see the faces on the video link on the TV. Okay. This court by an order dated 7/8/2024 directed.
Lordship, my humble prayer.
No, nothing doing.
Humble prayer. in the
No,
sense-
there was a.
There was a direction.
This is a case of you have
Also, there
taken
was a
somebody's
direction.
land without due process.
There was a direction, unfortunately, we are handicapped because the file is misplaced. So at least give us, next week time, I'm ensuring that I will make them.
Then otherwise this person
Yes.
has to be there.
Otherwise
Okay.
there.
Mr. S. Purva, government advocate submits that inadvertently the affidavit, which was directed to be filed by this court on 7/4/8/2024 could not be filed. He however submits that the said affidavit will be filed on or before 6th of September 2024. Lists the matter on 11th of September 2024.
Please.
This case, my lord, the petitioner has made a prayer before the authority of the GMC, my lord. Your lordship may kindly see, annexure C, page 16, my lord. So he has made a prayer for, my lord, reducing the height of the ground floor of his building from 6 feet to 12 feet, my lord.
Who is appearing for the respondent? Private respondent?
This prayer is not maintainable. Your lordship kindly see. In terms of the building code. My lord, the height of the ground floor for commercial building in a commercial state should not be less than 4.8 meters. Look, I'm just standing.
Then
My lord, here they want to reduce it down from 16 feet to 12 feet.
who?
My lord,
Petitioner.
petitioner. We have stated in our affidavit, your lordship may find it in paragraph 5 of our affidavit.
Then how can you?
Regarding whether the
You do one thing. You cancel this permission. Cancel this permission at all.
my lord,
This you
regarding-
cancel it because they want to violate this building. After taking this, they say they have given an undertaking that they will abide by the building bylaws. So you cancel it. Okay,
My
Mr.
lord,
S.
regarding
Dotto, the learned.
the progress of
No,
the
no, no, I'll do
construction,
one
whether
thing.
they have stopped it,
Let them cancel it.
My
This
lord,
is your-
regarding the progress of the construction, whether it is stopped or not, my lord, I have to take.
Who has
construction
got the
instruction
permission?
from
You
my-
have got the permission.
Yes, my lord.
You want the height of the ground floor to
Only
be
made a
reduced.
prayer, my lord, if
Huh?
it is not, only he made a prayer, whether it is accepted or if they don't accept, then he will continue with.
Withdraw. A.B. Chaudhary, the learned counsel appearing on behalf of the petitioner submits that in view of the affidavit filed by the Silchar Municipal Board and more particularly in view of Rule 43(4) of the Assam Notified Urban Area (other than Guwahati) Building Rules 2014, wherein it is stipulated that the height of the ground floor for commercial buildings in a commercial street should not be less than 4.8 meters, bracket 15 feet 8 inches, comma, bracket close. The petitioner would not like to avail, further proceed with the instant writ petition. Accordingly, the instant writ petition stands closed on withdrawal.
Obliged. I may be allowed 10 days time to file my affidavit.
Why?
Yeah, I'll like to raise the point of maintainability in this situation, Lordship, along with other factors.
Read it now. Verbally. Maintainability is on the question of law. Why do you need an
And
affidavit
I
for that?
also, Lordship, I need to.
They should not be directed to register or say registered sale deed in respect of one so and so and land measuring so and so Iman where total consideration of file only and has paid Iman and year. Now what is this? What are we asking?
Lordships, I have paid 5 lakh rupees to the respondent number 3, Lordships.
Ah,
As per the compromise, Lordships.
ah,
In this compromise, it was done before the honorable court, Lordships.
ah.
That amount, it was paid in the year 2000, Lordship, before 24 years. Lordship, now as on today, Lordship, there was an undertaking that we will execute the sale deed. As on today, Lordship, this respondent number 3, they have not executed the sale deed, Lordships.
There's some compromise.
Lordship, page 16, Lordship. Page 16, order dated 8/8/2000, Lordship.
You can have any sold by the next. There's a settlement.
Lordships.
Then if it is a settlement, this is an order, why are you approaching the writ court?
Lordship, we have approached time to time to them, Lordship.
No, forget about that. This is a decree passed in title suit number 24/75. Why are you not asking for execution? Why are you approaching the writ court?
Lordships,
How? Because the period of limitation is over. Yes.
24 years. Lordship.
Yes, no, therefore, period of limitation is 12 years. It is over. And there is no permanent injunction. So under such circumstances, if it is over, can this court exercise the writ jurisdiction, thereby directing them to do so when the period of limitation is over? Wouldn't this court then be sitting as an executing court when the executing court does not have the jurisdiction?
Yes, Surjit Singh Sahani case, Supreme Court has.
What?
Surjit Singh Sahani in Supreme Court in similar matter has decided that writ court is not the appropriate forum for extending the limitation in such a matter. Lordship.
See, Supreme Court also says, I only did not say that.
Lordship, he has been subscribed.
Lordships, I will obtain the instruction. Lordship.
The learned counsel appearing on behalf of the petitioner submits that he would like to take instructions.
Lordship.
This is the matter again on when? When do you want the faithful death of this litigation? When?
2nd week of September.
Huh?
2nd week of September.
Second week of any particular date you want when it should die? Any date. On 9th of September at 2 p.m. You won't have it in the first half. Don't want to.
Lordship, this matter pertains to payment of compensation.
Huh?
This non-payment of adequate compensation to the petitioner.
The
So
matter pertains to what?
payment of compensation. Now there are about 130 writs which have been filed, which has been actually this writs were filed in Arunachal Pradesh. This has been transferred to Guwahati.
So,
What happened? There are a lot of matters out there.
Yes.
Last time I got it
Yes.
here. What happened?
so all those writs have come here. So it'll be coming, coming.
No, there are many matters which have already
Have-
come.
have come.
These are all compensation, land
Yes, so
compensation
it has to
matters.
be together, so we require time, like, once it is there,
Have you got any series?
no. Not, series has not, so 130 matters, two sets of people are there. So require time, once those matters are there, we will be making two sets of, there are two sets of communities who will be getting the compensation, because the compensation is already paid. It's only about the enhanced compensation that is the whole, because
Who are you?
I'm NHS.
You are going to pay.
So I am objecting because state of Arunachal Pradesh have given the compensation as per the 2013 Act, which we are objecting to it, and that is what has to be brought in and through affidavit and everything. There are 130 cases.
No, they have passed an award.
No,
Then how is the question of payment?
no, it was
Right.
assessed. It was assessed.
Assessment is has no value. It has to be paid. Award has to be passed. Where's the award?
So award, to my information is, I think it has not been passed.
Well, who is challenging what then? What are you asking for?
Because the compensation,
Enhanced amount.
enhancement amount,
Why?
because they have calculated the amount.
No, has the award been passed?
Is
Award has not been passed. Then obviously they will get as per the 2013. What is there?
So award was already passed. They had got the money. Now Arunachal Pradesh government, and they said that no, now it will be as per the 2013 Act. This is where they are,
No, maybe if they want to go for 2013 Act, they have to make a reference, not this writ petition. What is this writ petition business out there?
130 petitions have been filed. That's what I have.
Oh, 130. Give the numbers, we finish up one day. Unnecessary. Now, how can this court decide? This is a reference court shall decide as to whether they are entitled as per 2013 or the 1894. Isn't it? Government advocate. Mr. A. Chandran, the learned government advocate of the state of Arunachal Pradesh, submits there are similar petitions. Full stop. He submits that let this matter be listed again on 18th of September 2024, on which day he shall provide the list of the various petitions which are pending before this court in respect to the same subject matter. Provide the list. Finish it off, unnecessary matter. What is this?
petitioners, my lords, are seeking relocation of a transformer. Now,
Why? Have you acquired the land?
the BSNL authorities, the BSNL had executed a lease with the landowner, and thereafter a transformer was installed in the premises. Now, what the petitioner is saying is that there are two adjacent lands. One belongs to the petitioner number one and one belongs to the petitioner number two. The case that they've tried to put forth is that there was a lease agreement between the petitioner number two and the BSNL. However, the transformer was installed in the premises of the petitioner.
And there is no agreement with the BSNL with the petition number one.
But
Then why the petition number two has come?
there is a mischief being played, my lords. I have instructions, but they've suppressed the very material fact, my lords. Petitioner number one and two are husband and wife.
Why you are not filing the affidavit then? With so much of mischief. This is a matter of 2023. Mr. B. Chaudhary, the learned counsel appearing on behalf of the FPDCL and
I put the respondent number 2, 3, and 4 for BSNL.
Mr. So-and-so appearing on behalf of the BSNL submits that they are going to file their affidavit in the matter, taking into account certain important factual aspects needs to be brought, which would be necessary for the purpose of adjudication of the incident with petition. List the matter on 25th of September. In the meantime, the affidavits be filed by 29/2024.
May I just point out one thing, my lords? In the writ petition at para 5, what they've contended is that they're neighbors, my lords. My instructions are that they are husband and wife. So that is what the case they've tried to do.
Your instruction is that they say on affidavit, you say on instructions. Why should I believe you? I will believe them. You are on affidavit, neighbors.
Please, your lordship. Due to unavailability of the authorized officer, the additional affidavit could not be filed, lordship. May kindly allow us 1 week more time to file the additional affidavit.
This court, by an order dated 29/7/2024, directed the petitioner, respondent, HDFC Bank, to file the affidavit.
UCO Bank.
Bank, lordship.
UCO Bank. UCO Bank, not HDFC.
What is this?
UCO Bank to file the affidavit, the respondent number 2 to file the affidavit. So however, the said affidavit could not be filed on account of non-availability of the authorized signatory. List this matter again on 25th of September 2024, on which day also, the affidavit, additional affidavit be filed without fail by 23rd of September.
Lordship, kindly pass over the matter for the day. Arguing counsel, Mr. JMS Obi is not well.
What?
Arguing counsel, Mr. JMS Obi is not well, lordship.
At the request of the learned counsel for the petitioner, matter stands adjourned to be listed. Be listed on 23rd of October 2024.
Affidavit has yet been filed. Affidavit has yet been filed, your lordship.
What affidavit?
Matter pertains to your lordship, use of our lands by the state authorities, your lordship, and our grievance is that it has not yet been acquired. The ones who have patta, your lordship, they still continue to pay revenue, your lordship. And those who do not, they have paid, Vedakali Jorimana till 2020. Your
Water resource. Who has taken the land? Water resource.
Water resource.
Problem arises with water resource. They have the habit of taking, they think 300A is not applicable to their department.
That land, their petition, they have stated that land acquisition process has not been completed. So.
How did you take the land?
DC has given.
DC? Who is DC? How did you give the land? Return the land. You don't have money, why do you take the land? Yes, Mr. Barbujari. They may requisition many things. They may requisition tomorrow the High Court also. It is nearby the Brahmaputra. Would you give it to them? They may requisition many things. No instruction. This court had issued notice. 6 weeks have gone. Yes, Mr. Barbujari. What type of this thing is going on?
Yes. Affidavit will be required, madam.
Why affidavit is required?
Because
Break the dike and give it to them. How much is their land? Where's the land?
from the lead petition, my lord.
Lordship, we've stated the lands at page.
Road construction is going on.
Yes, and we have protested, so the construction was.
Yes, we stop it immediately. Yeah. This court by an order dated 2/2024 issued notice. There's an LA case.
Lordship, there was actually an LA case in 97, 98. Thereafter, nothing happened. We sought information also. They have said that the circle officer has said that we have no record. At page number,
This court by the this court by an order dated 2/2024 issued notice. However, till date, there has been no affidavit filed or any instruction received, instruction placed before this court on the as to how the land of the petitioners have been taken over by the respondent authorities. The case of the petitioners are specific that their lands have been taken without due authority of law, and as such violates the mandate of Article 300A of the Constitution. Pustak. Taking into account that the respondents, in spite of notice, have not placed before this court any instructions. This court gives an opportunity to the respondents to place before this court their relevant instructions by 9th of September 2024. Failing which, this court this court would be constrained to pass appropriate orders either for returning the land to the petitioners or passing certain interim directions as brief.
We can send for taking the affidavit.
I don't know anything. 9th of September.
13 September.
We can have it on 6th. 6th of September.
6 of 13
9th is 9th. How are you taking their lands? You have your instructions. Why you are not placing? What is your instruction? How the petitioner's land are? Mr. Counsel, I am very categorical one thing. You, on one hand, if the government is always taking a stand as regards government lands, all other lands, you are very strict on that, will remain as strict as that. But in the same way, the government cannot take away the land of persons without paying due compensation. I'm very clear with that. This is not the manner in which you take somebody's land and make dikes out there. They break those dikes. You know, the public, first of all, he has a constitutional and human right. 9th.
Only one prayer, my lord, let the name of SC revenue be shown in the cost list. Otherwise, we are skipping the matter, my lord, for every time.
The name of the
SC revenue, that will suffice.
the registry shall show the name of SC revenue on the next.
I'm so obliged.
Yes, what is this? Oh, yes, Mr.
Lordship,
Counsel.
Lordship, item 32, I have. Lordship,
What happened?
Lordship, there is a subsequent development. On
Hmm.
9th of August 24, the state GST department, the respondent number 5 before your lordships, has issued a letter specifically saying that the ITC for two parties which are covered in the summons issued by the CGST authorities have been duly verified by them and the matter stands closed. I am handing over that letter, lordships. Lordship, on 9th of August, this is addressed to DGGI Jamshedpur, which is respondent number
9th of August, why have you not filed an affidavit?
Lordship, it came, Lordship, I am showing it, Lordship, it's a record. This is a single page that they have given. And Lordship, therefore, our challenge was, Lordship, Section 6(2)(b). Section 6(2)(b) of the Assam GST Act and the CGST Act, that where a proceeding has already been culminated by the state officers, the central officers on the same set of issues. Lordship, in the central GST.
There cannot be a parallel investigation.
Lordship,
But
parallel-
when our investigation has been done, can the central government not raise another investigation? That was my specific query.
Lordship, parallel and duplicate, there are two things. Duplicate can never happen in the eyes of the law because already for the same subject matter it has been closed.
Means just for example, the state GST, some officer do not give any importance to that, then the central cannot look into it.
Lordship, for the same
That
self issue
cannot be
for
the
this.
purview of section.
Lordship, I will place before your Lordship couple of judgments in this regard of the division bench of the Calcutta High Court also, wherein this has been recorded that if for a period an investigation
They
has been.
transfer this matter to Calcutta then.
No, Lordship, just replacing Reliance, nothing else, Lordship. I Lordship.
You want to file that affidavit being on record. What is your stand?
Well, on this.
You are creating the main problem.
Well, on Wednesday, I can have the instruction on clarification about this.
And what about you are creating also another
I have
problem.
received inspection, Lordship, this is
Yeah.
our report. Paragraph 5.
Because you see, if this tomorrow the state makes an there cannot be a parallel.
Yes,
There's no quarrel with that.
there is no-
But if an investigation has been done defectively, then can the state, or just for example, the central has done it defectively, can't the state look into that? It will have a far-reaching consequences. Yes, because there cannot be at one point of time if you are having two things. And there is no concept of this 300 CRPC type aspect.
Lordship, there is a concept of appeal. If the state is
Yes,
done a incorrect.
paragraph, Mr.
Paragraph 5, Lordship.
Huh?
Paragraph 5. Page
It
11.
appears that a matter of availment utilization of irregular inadmissible ITC from the area and so are under investigation with the state GST, and therefore, if approved, the same may be closed at the end as per the provisions of demand to avoid parallel investigation. So now, Mr. Counsel,
Lordship.
as per their information, what they are saying,
Lordships.
they are in your favor.
Lordship, that is one Lordship, that your Lordship just read it.
No, the central government is also in your favor. That is why I'm saying, they say that it appears that a matter of availment utilization of irregular and inadmissible ITC from Riddhi Industries and so are under investigation with the state GST of Assam, and therefore, if approved, the same may be closed at this end as per the provisions of section 6(2). So they say that it is the central stand. No, under such circumstances, you bring this aspect by way of an affidavit.
Grateful to you.
Let me
Lordship.
close it.
Grateful to
Okay.
you. Grateful.
Lordship, 5.1 very kind. 5.1.
5.1 is what? Further, the taxpayer has received ITC of so from Iman during 2020-21 after cancellation of GST registration. No other authorities except DGCI Guwahati Zonal has initiated investigation as per the documents available till date. Therefore, investigation as regards may be continued.
I am not on that Lordship. I was only on these two parties for which the state has concluded. I am not on the ISA.
Mr. Counsel, we have it on again on 9th of September.
9th of September, Lordship.
Yes, you file an affidavit.
Lordships.
As I have informed you about this
Lordship.
thing. You
Lordship.
file an affidavit that you are only limited to this. You have no
Lordship.
objection as regards this ISA thing and all. And
Lordship.
you on record this, and the government, you come up with this thing as regards.
Lordship, may I seek a copy of this report filed by learned friend?
They have not filed. They have only
Lordship.
given it to me.
Grateful.
Just can you hand it over? Give it. This is not in the here. Are you claiming here? Investigation report of Contempt Industries by incident by when it is dated. This is
my instruction.
incident when there is no date.
No, this is my
We
instruction.
have only given a half of it.
No, this is my instruction only. That's why-
Okay. He has only given 11 out of 48 pages.
Lordship, that's fine. Lordship. My purpose is being solved by that 11 only, Lordship. Grateful to you, Lordship.
Okay, let me note it down.
Grateful to you.
This court, by an order dated 26/7/2024, had issued notice and notice in pursuance thereto. Notice. It is very pertinent herein to mention that the petitioners herein have approached this court challenging the initiation of investigation proceedings by the central authorities under the CGST Act 2017 on the ground that the said aspect of the matter has been already investigated upon by the state, Assam State GST authorities. Full stop. Be that as it may, Mr. A. Kano, the learned counsel, Kanodia, the learned counsel appearing on behalf of the petitioner submits that on 9/8/2024, a letter has been issued by the Assistant Commissioner of State Taxes, Sibsagar, to the Deputy Directorate General of GST Intelligence, stating inter alia that the input credit availed by the petitioner industry in respect to the parties, namely MS Riddhi Industries as well as MS Amazonite Steels Private Limited, are genuine and eligible. Full stop. This court is of the opinion that the said document be brought on record by filing an additional affidavit. It is also relevant to take note of that instructions were placed by Mr. S.C. Kyle, the learned counsel appearing on behalf of the CGST, who submits that the matter of availment of utilization of irregular and inadmissible ITC from MS Riddhi Industries and MS Amazonite Steel Private Limited are under investigation with the state GST of Assam, and therefore, if approved, the same may be closed at the end of the central authorities as per the provisions of Section 6(2) of the CGST Act 2017 to avoid parallel investigation in the same matter. However, it is also mentioned that in respect to the ITC of rupees 19,04,328 from MS ISA Sales Private Limited during 2020-21, after cancellation of the GST registration, no other authority except the DGGI Guwahati Zonal Unit have initiated investigation as per the documents available till date. Therefore, the investigation in respect of IESA Sales Private Limited should be allowed to, ought to be allowed to be continued. Full stop. Mr. A. Kanodia, the learned counsel appearing on behalf of the petitioner, submits that the instant writ petition only relates to the input tax credit of MS Riddhi Industries and MS Amazonite Steel Private Limited, and the petitioner has no objection in the investigation so carried out in respect to MS ISA Sales Private Limited. Full stop. This court is of the opinion the said aspect of the matter be also brought on record by in the affidavit to be filed by the petitioner. Full stop. Mr. B. Gogoi, the learned counsel who appears on behalf of the state GST, shall also verify the contents of the communication dated 9/8/2024 on the next day and submit accordingly.
Grateful,
Yes, Mr. Counsel, I think now we can close it after you file that affidavit.
grateful, dear Lordship. We will get it. Grateful.
We'll see later on. We are taking it on 25, no? We will make it earlier date. Don't evict. Have you evicted them?
No.
When did I fix the date?
25/9.
25, na? We'll do one thing, we'll have it up, prepone it. Because that has not, it has been cancelled. So we do it on 13th of September. Wait till 13th. On that day, because she was here, I passed it on. We just prepone it.
Nice.
Item 33.
And just find out whether it comes in the water bodies, huh? Whether it comes in the water bodies, because once it is a water body, it is out. The question of settlement or anything does not arise. Yes. Oh, yes, what did you have?
Once if I have received instruction, ITO has requested the CI to treatment for early hearing of the.
We do one thing. The principal commissioner of income tax to dispose of this as early as possible and preferably within 2 months. They also, it is also the area of the income tax officer. So we direct them to see to it to dispose it of. And you need to, have you filed your written arguments in both the matters?
Okay.
Huh? In both the matters, it has been filed. The heard Mr. A. Ganguly, the learned counsel, appearing on behalf of the petitioner, Mr. S.C. Kyle thus appears on behalf of the income tax department. The petitioners in the instant with petition have approached this court being aggrieved by the delay in disposal of the appeals filed in respect to the assessment year 2020-21 and 2018-19. This court এটা কাম করো আপনি এটি petitioner has come বলে আছেন না এখানে প্যারাগ্রাফ 4 আর 5 টু আগর অর্ডার টু কোড করে দিবেন কোড করব না আনি দিবেন ও pursuant to the above no first of by the order dated 9/8/2024 this court directed the Standing Counsel of the Income Tax Department to obtain instructions as to whether those appeals have been disposed of, or if not, when such appeals can be at the earliest disposed of. Today, Mr. S.C. Kyle, the learned counsel, submits an instruction which is kept on record and marked with the letter X. An instruction dated 22/8/2024, which is kept on record and marked with the letter X. From the said instructions, it is also seen that there is a recommendation being made by the Income Tax Officer Ward 2, Guwahati, to the Principal Commissioner of Income Tax, Guwahati, for giving a priority disposal of the appeal. This court inquired with the learned counsel appearing on behalf of the petitioner as to whether the written arguments have already been filed in both the appeals, to which Mr. A. Ganguly submits that the written arguments have been duly filed. Under such circumstances, this court is of the opinion that there should not be any difficulty on the part of the principal commission on part of the first appellate authority to decide the appeals at the earliest. In that view of the matter, this court directs the Principal Commissioner of Income Tax, Guwahati, to ensure that the appeals which have been filed by the petitioner for the assessment year 2020-21 and 2018-19 on 18/10/2022 and 10/4/2023 respectively are disposed of within a period of 2 months from today. Mr. Esikael shall duly intimate the principal officer, principal commissioner of income tax, Guwahati, for doing the needful in that regard.
They may not initiate the coercive proceedings.
It is further directed that as this court has specifically directed the appellate authority to complete to dispose of the said appeals within a period of 2 months, comma, no coercive measures be taken on the demands till the disposal of the appeals.
Item 34.
May please, my lord. I preferred one additional affidavit, my lord.
Which one?
My lord, it's page 31, running page. My lord would kindly have page 32. My lord, we had been paying Khazana, my lord, in this case, my lord, for dark number 545. It came to our notice that that was the wrong dark number. It should be 397 where we are deciding.
Huh?
Page 32, my
You have
lord.
been evicted?
No, not evicted.
Very well. Good. Now what happened?
My lord, we had been paying Khazana, my lord, at annexure 1, my lord, page 17 of the writ petition. We were paying Khazana, my lord, but that was in the wrong dark number.
Government cost land having them cut. It's a government cost land, not roadside.
PWD ka. This one seater.
It's a remark, it is mentioned at PWD. You cannot have a roadside meaning PWD side.
And
But in the draft CETA it is shown, but in the what is otherwise it is mentioned.
trace map is there also.
Where?
There
Where's the land?
5. Dark portion is 516. Only.
One.
Yes, that's.
This is not roadside. Then are you taking any action in respect of all other lands? These are, how do you say? Mr. Counsel, you show me one thing. These are given in 519 and 519. Notice was given in 516. And 516.
Only 516, my lord.
516 is where?
It's at page 30, my lord, 30. 29 is the translated, my lord.
Did you apply for settlement in these lands?
No, my lord.
Then you have to be thrown out.
My lord, I seek liberty before this honorable court. I seek liberty before this honorable court that we may apply, my lord.
No, you don't apply. That is your lookout. You don't apply, what do I do?
My lord, may I please submit? My lord, they are poor uneducated people, my lord. They do not have the concept of applying. Now they have come to know.
Nowadays you don't require education, no?
My lord,
Why do you require
my
education?
lord, very limited knowledge, my lord. Poor people, my lord. Will apply, my lord.
Uneducated persons are signing in English.
My lord. My lord, basic education, very basic, very low level of education. Not so much that they would foresee that one day they will be thrown out from the
So
land.
they would also not understand what is written in English.
Well, SMEs, the notice was given, Janoni at page 30. my lord.
No, the petition is in English.
Yes, my lord.
There is no mention out there to that effect that this has been explained to me. translated by my lawyer. And you are saying uneducated.
Very basic.
Don't come up with this. Lahore. This court, by an order dated 19/8/2024, directed the respondent authorities observed that the respondent authorities can go ahead with the eviction, provided that the land in question is a roadside are previously roadside reserved land or previously reserved for roads. Full stop. Today, Mrs. S. Purva, the learned counsel, appearing on behalf of the respondent, more particularly the district commissioner, Walpara, submitted that there has been no eviction carried out.
No.
He further submits that from the records, it is available that the land in question is a government khas land measuring 1 bigha, 3 katha, 7 lechas, having no land class in the chita, and in its remark column, it is mentioned as PWD Kho, KAH, meaning PWD side. And in the draft chita of the said land, Dag is found as PWD Rasta Kho, means PWD roadside. In that regard, the report, the chita as well as the trace map have been placed before this court. The said instruction is kept on record and marked with the letter X. This aspect of the matter would require a further adjudication as to the land in question is actually a land which have been previously reserved for roads or is previously reserved roadside land. Accordingly, this court fixes the matter on 23rd of September 2024. This court further directs that taking into account that there is no clarity as to whether the lands in dark number 516, wherein the petitioners are in possession, are previously reserved roadside land or previously roadside land reserved for roads. This court directs the respondent authorities not to carry out any eviction till the next stage. Oh, this one. Kita tu thim mati. Na? Untuk daya anu. Any interim orders to be extended? No, na?